order, my lord. Rejection of recall order. Informant appeal has come file this case, my lord. This matter was listed, my lord, on 6/3/2025, my lord. That day court did function after 2, my lord, PM, lordship, my lord. And this noting has come, my lord, that day.
What do you want?
My lord, order ta dekhun what order your lordship pass, my lord. Se kale short date kariya apan kahithile. Setire 24 order mistake heichi. Plus ଆମେ notice ଦେବୁ police କୁ ଲେଖା ହେଇଛି plus put up vacation put up ହେଇଛି
time road mistake
after vacation ମାନେ during vacation period ମୁଁ ତ କହିଲି ଆପଣ କହିଲେ ସେଦିନ ହେଲା ନାହିଁ ଠିକ ଅଛି ଆଉ ଗୋଟେ short date ଦେଇ ଦିଅନ୍ତୁ 200 order mistake ହେଇଯାଇଛି 24 ରେ order ହେଇଛି ଯୋଉଟା କି 25 ହବା କଥା 6/3/25 ହବା କଥା ଆଉ ତା ଦେହରେ put up this matter ପୁରା 5 vacation ରହିଛି
अरे
ସେଟା tomorrow କୁ ଆସୁ ମିଲଟ so that urgent matter ମିଲଟ
नारायण
ତଳକୋଟ ପିଲା କାମ କହୁଛନ୍ତି ନା
our regular steno was not there.
ଆମେ ସେଟା ଆମ କଥା tomorrow କୁ ଆସୁ ମିଲଟ ନୋଟିସ ଆଭଏଡ କରି ନେଇଛି ଦେଖନ୍ତୁ ନୋଟିସ ଟା ନେକ୍ସଟ ପେଜ ଟା ନୋଟିସ ଆଭଏଡ କରୁଛି ଇନଫରମେସନ
Day after tomorrow.
before man
Pardon, mention crossing
He is written. I don't know. I also can't understand what.
क्वालिटी हुई हमर को भूलू नहीं
But he is,
सामे भूल कहू ना हमरे कहू
see these people, those who are in the court, they know the procedure. If somebody comes, there is a problem,
sometimes
and you can't afford to see every proceeding.
ना एटा कोन होची बेले
That's the problem.
सर्कुलेट 85 मिनट
100 proceeding. How will you see?
से बड़ा
Small adjournment also, if you start looking at, then it's not possible.
नेट न आइलो प्रॉब्लम नहीं नेट बेले आछि छुट्टी रे आउची डेट
We'll see. I'll think.
pardon, mention my lord.
चलो
I know. He's very. Today, all of us are safe. Yes.
Crossing of the cognizance order, my lord.
You please give the memos because he for 2 days only he has come. He just will see.
Another is
Please give the
NBW.
memos. All the memos, please give. Need not mention. I'll see.
Yeah.
Please give all the memos. We'll see. Yes.
Modification application.
Please give the memo.
The MBW cutting up CMP possible next week.
You give all the matters. I'll try to accommodate somehow.
My lord, this is CLMC. My lord, the honorable court below has posted this matter to 21st. My lord, my kindly listen.
When have you filed the petition?
My lord, it was specifically adjourned to 24th of January, but not at least tomorrow. My lord.
Okay.
Grateful.
Yes.
Supplement list, page 1.
1 minute. Mishra is saying that. Please give that. We'll see
which one
the memo.
yes
Please give that.
my bank account and the vehicle has been seized by ED though I have no involvement in the crime these are all loan accounts sir
Yes.
because of March that's why I have come now it's taken up tomorrow
Not tomorrow. Not tomorrow. Not
day after your lordship may consider
Day after we'll see.
Day
Day after. Yes.
Item 4 on behalf of Mr. Sunil Kumar Panda, bring 1 new captor.
4.
Item
On
4.
the request of a request is made on behalf of the counsel for the petitioner for an adjournment. Yes. 4.
Well,
Yes.
item 6, I pray for an adjournment.
6.
Yes.
Same. On behalf of who? Ramanikant Patnaik,
Patnaik.
counsel for the petitioner.
Well, item number 3. Item number 3. Prefer
3. Yes.
One extra copy is opioid matter.
Give the copy. 6. Who has mentioned? Madam, who has mentioned 6? Give the copy. Okay. Yes. 3.
Item
3.
3. Prefer
Adjournment. Same request on behalf of Mr. D.
Item number 2, your lordship adjournment.
Huh?
Item 2.
2. So why these matters are being listed? Everybody is asking for adjournment. 2 we got on the request of Mr. Counsel for the petitioner. All these matters will go to June only. June, July. Yes. Next page. Page 8.
Page 2.
Item.
Item to
Item koi din.
Item 2, page
Nahin,
2, 11 to 24.
11 to 24. Yes.
Page 3, 25 to 39.
Item 20.
20. Yes.
28.
28. Yes. What do you want?
Praying for an adjournment.
Adjournment. You have become a master in adjournment. Every time, 2-3 adjournment you are taking every day. Yes. On the request of counsel for the petition. Yes.
Page 4, item 4250,
My lords, item number 40. The 600 adjournment.
40, yeah? 40. Okay. Press matter. For petitioner?
Your lordship.
Yes, for petitioner. Yes.
page 5, 51 to 61. Page 6, 62 to 17. Page 7, 71 to 76.
My partner to mention item 73.
Yes.
Kindly be adjourned after 2 weeks.
On request of petitioner.
Published.
Page 8. Page 8, 77 to 83.
My lordship, item number 81. Seek for an adjournment on behalf of the petitioners.
Interim order is there.
No, it's
Okay. 81. Counsel for the petitioner.
81.
Yes. Yes.
Page 9, 84 to 88.
No, 84 item. Pray for an adjournment. Item 84.
84. Yes.
Pray for an adjournment, ma'am.
Interim order is there.
Yes, ma'am.
Then wait. The other side may comment, of course. Yes. Next. No. Let the
Page 10, 89 to 98.
89, my lord.
yes.
I will file a affidavit, the matter of a POSCO, my lord. But the victim and the petitioner has already been married. I will file a affidavit to that effect.
My lord,
These are
item
on
90.
request of counsel.
My lord, item number 93, my lord. The wife opposite party, my lord, already been appeared for 98 case to make the compromise, my lord. So may it be fixed to 2 p.m., my lord.
Today date is fixed. Call them.
My lord, already appeared, my lord, before the court, my lord. 2 p.m., my lord. They can-
Are they coming today?
Yes, my lord.
Okay. 2. Okay.
Oh, please.
My lord, item 92.
92.
And for the opposite party number 2, I pray for an adjournment, my lord, to file the
Who is for
counter.
petitioner?
My lord, Mr. Bigyan Sharma, we have already informed his office.
Inform.
We prayed
And,
for the
Interim order
continuation
is
of
there.
interim order. Yes, my lord.
On the request of the counsel for the opposite party. Adjourn. Interim order to continue. Yes.
Page 11, 9900. Open the list.
Who is currently here? Yes.
Open the list. Presiding item 1.
Yes, please, may I please watch? The petitioner is a lady advocate of Salepur Bar Association,
Yes.
facing lot of difficulties doing in the opposite party. Number 2, causing nuisance. Thus we challenge the order under section 133 CRPC,
Yes.
which is passed by the opposite party number 3, sir.
Where is that order?
That is the order is
Service is complete.
16.
Who is appearing?
This is a fresh admission, issue notice to the person.
No, there are many orders passed. What is this? Item? One.
One. This
We
is the
don't
fresh,
need that.
this is the fresh admission, my lord.
1 minute. There are lot of hearings taken place. 1, 2, 3, 4, 5.
Yes,
What
my
is
lord,
happening there?
that is dismissed by in non-appearance, so we file a CRLMA and that is passed by your lordship court. And then we come, that is the fresh admission. Yes.
Then issue notice to opposite
Yes,
party.
madam.
Correct. Issue notice. Okay. Yes. Yes. Next.
Item 5.
Pass. Pass out.
7.
May I begin to plead the lordship, madam? My lord, against the order of NBW, this CRLM says in 5.
Yes.
Hello? Against the order of NBW, madam.
NBW.
Yes, madam.
Where is that order? NBW.
15th September.
You are on bail.
My lord.
You are on bail.
5/3/20.
5/3/22. 5/3/22 bail. NBW 15/9/2020. ठीक है 2022 ठीक है 1000 करेंगे पूरी तरह ओके अलाउड
My lord.
8. Item 8.
Yes. What is this matter?
This is, there's a mutual divorce, but no document is there.
Cognizance.
Cognizance. They are alleging that the mutual divorce, but no documents in the place.
What are the offenses? Think is fine.
76.
Right on. Petitioner is seeking quashing up to the order dated 5/1/2024 passed by SDG Bhadrak in GR case number 1932 of 2023, whereby the cognizance of offences punishable under section under section 376(2)(n) 506(34) IPC read with the section 66E and 67 of IT Act has been taken against the petitioner. Except the impugn order, no other documents have been filed by the petitioner in the with this petition. Therefore, one opportunity is granted to the petitioner to place on record additional document, release the matter after 2 weeks. In the meantime, petitioner is at liberty to file the additional document. Yes.
9.
My lord, I have filed this application challenging the order of NBW dated 28/10/24. The petitioners were on bail, but on 28/24, the NBW has issued against them by the landed court below.
When we give the date of the bail,
NBW 28/10/24.
Yes.
And
Bail?
bail 1/8/18. Another 2 persons are there. Another 3/8/8.
Okay. Okay. 500 each. Yes.
My lord, the application for
Yes. Next. Allowed. 500 each.
10.
10 lordship 500 for lordship. 10 টা 500. Lordship 10 500 for.
Pass over. Pass over. Yes. 11.
11.
Wait, please, my lord. The petitioner challenges the cognizance order dated 15/11/2023, passed in city case number 1339 of 2023, my lords.
Yes.
Lordship may kindly have a glance at the FIR that is under Annexure 2, the relevant portion being the page 12, your lordship.
Where is the charge sheet?
My lords, charge sheet Annexure 3.
Yes.
Lordship may kindly have a
What
glance
are
at
the offenses?
offences under section 341, 294 and 506 of IPC, your lordship.
Yes.
Harassing to the colleagues. Office. In one office, the harassing to the colleagues.
My lords,
Colleague.
Colleague.
Okay.
Lordship may kindly have a glance at the page 12, your lordship.
Yes.
The FIR, the complaint has been registered. My lord, there's 5 or 6 lines. I may read that, my lords. Kindly.
Yes.
I am Deepika Rai, such and such. One of our colleague named Subrat Padi, the present petitioner, my lords, of our company is repeatedly harassing me by using slang language and threatened me in office premises. Thereafter he said that he threatened me like for which if he will be harassing me so that I will be forced to give resignation and every time facing mental harassment at office. The second part that he threatened me like for which if he will be harassing, it is an assumption.
Come to the charge.
The first part, my lords, lordship
interpreting the FIR.
My lords, lordship, see, the complaint state that only slang language, but the FIR has been
Come to the charge sheet. What
my lords, charge sheet,
come against you?
Page 19, your lordship. Page 19.
Yes.
The relevant part.
Yes.
During course of investigation, that the second para, your lordship. Page 19, second para.
Yes.
During course of investigation, visited the spot, examined the complaint and witness and recorded the statement under section 161. Seized 3 number of Xerox copies.
Statements.
The statements are not available with us. Charge sheet will be filed through.
Show me the statements, whether in case made out or not.
This is the first.
Statement of the victim and the other witnesses. What they have said, whether you are really harassing the girl. In the
Yes, only statement that I am use slang language, but 341 offense has been added. 341 says punishment for wrongful
Where is
consent.
the statement? Have you read it?
The
Without reading your
but the FIR at the prima facie value.
FIR is nothing.
After it's not an encyclopedia, my lords.
After the investigation, what you exactly have done, everything.
The state council may kindly
just
at the CD, my lords.
Why don't you settle? Why you are first of all you are harassing a girl?
Not harassing. I have been discharged from my service. It's a private company, my lords. She was the HR head. I was working under her, my lords.
I issue notice, let us see, in the meantime, if anything can happen, because the offenses are very minor. Now you are out of job.
Out of job.
You are not working in this.
No, I'm working in another company, not in that.
Not
company.
in-
Not in that company.
Then
That's why my
they
insight.
may settle now. Yes, issue notice, let us. Issue notice. Yes.
But IFO, my lords, kindly the trial court kindly be at least if the adjournment sought for my kindly be granted.
No, no. First of all, you have not filed. all the
161
documents.
statement, my lords, that is.
I'm just
part of the
giving intelligence
case.
because I want that at least they should, if the young people, why should they fight in the court?
161 statement.
Documents.
Sorry?
Would have collected all the documents.
Because charge sheet has been filed, the copy might have been given to you.
My lords, charge sheet, I have obtained the certified copy.
Then the statement must be
Statement,
there.
I will obtain.
Statement must be there. Let him move application why to aggravate. The young people working in two different this thing, only very minor this thing. They are not criminals. Let him move application for adjournment.
Much obliged.
After 2 weeks, file the document.
My lords, I will file in a minute.
Why will you go to mediation?
Let them appear if they are willing to, my lords. Let them appear. There is notice may be.
Not there. You have to tell.
I am willing to for
Tell
mediation.
sorry to that lady.
I am willing for mediation.
I'll send it to mediation.
Mediation.
District mediation center. Where is that? 11, na? Item 11.
My lords.
There will be only after issuance of
Notice.
I issue notice, but at the same time, I'll send it to mediation. Let us see. Where is that item?
11.
Which district?
Bhubaneswar, lordship. JMFC 2 Bhubaneswar.
Regarding head to the nature of allegation made by the opposite party number 2, have you implemented
My lords, opposite but not
opposite
2.
party number 2 against the petitioner? I am up for the considered view that the parties may explore the possibility of a settlement. Hence, referring the matter to district mediation center. The coordinator of mediation center should fix a date and intimate the party. Go there. In the meantime, the petitioner may move application before the trial court for a year.
Much obliged.
Yes.
12.
And also we're moving two quashing petitions. In fact, one has got listed today and the other we've already moved a memo for listing. The petitioner and the opposite party were married in the year 2015. My lord, it was an arranged marriage where the petitioner husband was based in Gurgaon and the girl was based in Bangalore. The girl was suffering from chronic kidney disease and the said factum was hidden from the husband. And therefore, thereafter, my lords, the husband moved a petition for declaring the marriage null and void.
No, you have settled the dispute.
Yes, my lords, we have settled the dispute. It's coming up for quashing of the DV case as well as quashing of the 498A.
Where is that? The other petition?
My lord, that I have already given a memo. That was the earlier petition. It has
Then
not.
both the matters are listed.
Yes, my lord.
On a particular.
Yes, my lord. I've already given the memo today.
Your memo, give the number. Please the
I've
matter.
already given.
Please
I'll just give the
petition
number.
along with the connected matter being
My lords, I can give 4723 of 24.
CRLMC 4723
of 2024.
2024 on a fixed date. Give it on when can you come?
My lords, whenever, my lords.
April 11th April. 11th April.
Obliged.
Bring them. I'll bring them.
My lords, otherwise notice may go. I don't know. Somehow the lawyer who was handling says I have no instruction. So
No,
we'll try.
in this matter, issue notice also.
Issue notice, my lords, and I'll give a cover letter
Issue notice
to be present on
along with so on 11th. Okay. If you want a little early date also, I can give.
Yes, my
because
lords.
it can be
Yes, my lords.
both the matter can be settled.
My lords, if notice is issued, at least I'll be in a position to give a
Let it be on 4th.
4th of April.
4th April. Okay.
Obliged.
4th April. Yes.
13. May I please, Your Lords? My lord, this is a pure spell question on the ground of compromise, my lord. And the petitioner is the student, my lord, and opposite party number 3 and 4 are the student.
Yes.
They meet an accident.
What are the allegation?
Allegation, my lord, accident case, my lord. 279, 337, my lord. So
He has received 30,000 rupees. That is the allegation.
Issue notice.
Notices.
Let us issue notice. Yes. Next.
14. Maybe 2 weeks time, man.
Oh,
After election. Man.
This is the contest person.
Candidate.
your candidate.
2 weeks after.
Up to 2 weeks.
Oblige, my lord.
15.
May I please, Your Lordship, my lord, I have filed this application for quashing of the affair, but I am not moving this case on very first or second hour. I will be satisfied.
What do you want?
First or second or same day.
Although the petitioner had challenged the order dated,
My lord, affair, I have filed the application
FIR.
quashing of the affair.
investigation is going on.
Investigation is going on and charge sheet has already been filed in the instance of the some of the co-accused persons.
You are absconding.
ମୋ ନାଁ ନାହିଁ କିନ୍ତୁ ଖୋଜୁଛନ୍ତି for that reason, my lord, I want to
So
surrender.
why will you?
ନାଇଁ,
If your name is not there, by
161 FIR ରେ ନାହିଁ କିନ୍ତୁ 161 ରେ subsequently add ହେଇଛି.
they may file, they may not file. Why are you inviting this? I don't know.
First or second କରିବେ ନିଶ୍ଚିତ confirm.
Charge sheet is not filed.
No, no.
Look, although the petitioner has challenged although the petitioner is seeking quashing of the nursing guy, what is this? Marsagai case number 366 of 2023. 2023. However, he submits that since the investigation is going on with the case, you would not be pressing this application. Full stop. Rather, counsel for the petitioner further submits that he will appear before the court. He will appear before where?
Before the Lord HD Jam Kendrapada in the first hour.
Before the
HD Jam Kendrapada.
Concerned court.
In the first hour.
And resort to the remedy available to him under law. He further submits that the co-accused persons have already been enlarged on bail.
Yes, my lord. Some of the
co-accused persons have already been enlarged on bail. Charge sheet against him has not yet been filed. He submits that he is entitled to reparative. Let the petitioner appear or be surrendered before the concerned court and resort to the remedy available to him under law. And liberty is granted to petitioner to move to appropriate application for grant of bail. If such application is filed, the same shall be considered by the courts below, plural, courts below on the same day.
Oh, blessed.
Yes.
Case diary made available.
Testing.
Parity payments, parity.
Parity.
Oh, blessed.
Yes.
May I please, Your Lordship? Item 16, my Lordship, the petitioners are challenging the proceeding initiated against them on Jodhpur Mahila Police Station case number 37.
Is it 498 case and all? I'll issue notice. Issue notice to opposite party. They have separated. Divorce degree is there.
Yes, my Lordship.
It is not within the diverse. It is alleged.
No, he has filed some degree, divorce degree.
It is behind back of the.
Nyalaya, Pradhan Nyalaya, one Raipur.
Back.
Kutum Nyalaya Raipur.
Page 28.
My Lordship, on
behind back of the.
You are in custody.
No, my Lordship.
Behind back of the divorce was made. Without her notice.
Okay, then I'll simply issue notice. Issue notice. It is an ex parte order. Yes.
17.
Okay.
May I please?
17, my lord, sir. Copy is required. It's fair. Does not serve the copy.
17.
Maybe.
Copy, sir. I will serve another copy.
I verified not. It's fair copy will do.
I'll
give a copy.
I would
I'll issue notice then. Huh? Sure. If you notice, give a copy.
18.
May I please, Your Lordship? The petitioner here challenged the parallel proceeding initiated by the opposite party wife, Your Lordship. The marriage was solemnized between the petitioner and the opposite party number 2 in the year 2013, my Lordship. In the year 2017, divorce proceeding was filed. Thereafter, the opposite party wife lodged an affair on dated 12th of April 2024. And it was pending before the learned court below. And after 6 months, another complaint case has been filed on the self-same allegation, Your Lordship. Page 23, Your Lordship, have a glance, Your Lordship. Annexure 3, page 23, the FIR, Your Lordship.
Yeah, I've seen it.
Page 23.
Yes.
The offense for
Seeking quashing of what? The
question
complaint
was
case?
not a complaint case, Your Lordship. Page 33, Your Lordship. The complaint has been
Okay,
filed.
issue notice this. The opposite party is the wife of
Petitioner.
number 1.
Yes, Your Lordship.
The husband, the
I
party
did
in
not
it.
let us issue notice. Yes.
Wife, my lord, opposite but not proof.
Yes, next.
My lord, since the learned court will issue notice in the complaint case, my lord, I have filed the IA, Your Lordship.
Only notice has been issued, nothing is going to happen. You
Lord,
start the process within 2 weeks it will come.
Otherwise, my lord, the learned court will proceed with the complaint case.
So what will happen? This is a matrimonial dispute, nothing is going to happen. Yes.
My lord, but it is maintained, my lord. Section 210, Your Lordship, clearly, my lord, says that two parallel proceedings cannot maintain, Your Lordship. Our High Court also, my lord, held that.
There are many points where I can dismiss also.
No.
You insist. So, this is a matrimonial dispute. I am simply issuing notice. I want to see that it can be settled.
Yes, Your Lordship.
Okay. Let us wait. You file the process immediately by tomorrow.
Yes, Your Lordship.
You bring them. I'll see that both the matters are settled.
Obliged, Your Lordship.
Because there are suits, there are this, that, so many disputes. Only matrimonial dispute.
Matrimonial dispute.
What is happening to marriage?
Marriage, my lord, they are separated age, my lord. Since
Separated?
2017.
But have you filed divorce petition?
Yes, my lord. The husband filed divorce petition in their 2017, my lord. Yes.
So it can be settled then. There is no question of staying together. It is a money matter now.
My lord.
Get ready to pay some money and finish it up. Yes.
Obliged.
19 on behalf of Mr. Palmela, kindly pass over.
Pass over.
20.
May I please, Your Lordship?
Vigilance.
Lordship, I am on behalf of the Rajat Kumar Panda. My lord, petitioners may be permitted to withdraw.
Permitted to withdraw?
Yes, my lord.
Well, give a memo.
Yes, my lord.
Mr. A. Pahi.
Business matter.
Counsel for the petitioner. You are appearing for whom?
Petitioner.
Okay. Seeks to withdraw the petition. Give the memo. Okay. Start
Yes,
with
Obliged, madam.
21. Yes.
21.
May I please, my lord? My lord, here petitioner filed this petition for quashing of criminal proceeding initiated against the petitioner. Fact is that, my lord, POXO is involved, my lord. After the girl is rescued, that is annexure 2, my lord, page 12, she has stated in her 161 statement, they got married with the consent of both the families before the Kakorpur temple. So your lordship may issue notice.
Okay, issue notice. And you see the recent judgment by passed.
Yes, yes.
That may help you. Okay. Issue notice. So you have impleaded informant. And
Yes, yes, I have already.
And victim also implead.
Victim, my lord, mother of the victim, my lord, I am.
But I want to hear from the girl that she is happy.
Yes, she will come, my lord, with affidavit.
Okay.
She will come with affidavit.
He should be happy, that's all.
Yes, yes, they are not living together.
Okay. No, this is 21, na?
22, sir.
21.
What is your age? What is your age?
At the time of
29. 29. You were earlier married? No.
Yes, my lord.
You were earlier married?
No.
At
the time of incident, 13 years. Victim.
13
years. Now
this affair was registered in 2024. ବର୍ତ୍ତମାନ ସେଟା ଜାନୁଆରୀ 24 ରେ ଏଫଆଇଆର ହେଇଥିଲା ତାଙ୍କ ମଦର କହୁଛନ୍ତି 13 years ମାଇନର ଗାର୍ଲ ବର୍ତ୍ତମାନ ଆଟ ବେଷ୍ଟ ଏଇ 14 ପ୍ଲସ୍ କି 15 within 15 ପାର
My lord, let
Charge sheet file.
That part I have no instruction, but case in a turn.
Check it up. What
Yes,
is the
your
age?
lordship. Yes.
The mother might have said 13.
Yes,
Who
yes.
knows?
Yes, yes, that's
Maybe generally they say 13, 20.
No.
Like that. I we should notice that verify that fact also. Okay.
obliged.
22.
May I please challenge the order of cognizance, the complaint petition and also the evidence on affidavit I have filed. If at all, after going through the complaint petition and the evidence of if at all, then the alleged fact only can disclose a commercial dispute because the petitioner is an architecture. The complaint is that page 12, may I take your lordship, is that it will be clear that some of the things I have not done, then the architecture has asked for that you have not done this in timely, you have not done that, then the architecture has said that yes, all those communications I have filed. Notice may be issued, then only notice may be issued because that architecture engineering
These are the
is
commercial transactions.
Yes.
Yes.
Commercial transactions.
That is there.
The contract was given to the architect. She has not done
Done
satisfaction.
Yes,
That doesn't mean that a criminal case.
that is there, your lordship.
If criminal cases are being registered in this way, then end of the matter. Yes. Issue notice.
Stay up for the proceeding, my lord, I have filed and
I move an application for adjournment. Application.
Public.
Yes.
23.
File this CLMC to quashing the entire criminal proceeding in view of the compromise.
Compromise?
Yes.
What are the offenses?
Offenses under section 296, 109, 303.
Hey, what are the allegations? Sir?
Allegation based on governance to the dispute arose between the parties. The matter has been settled between the parties, the intervention of villagers and gentlemen. Honest to be escalated, jhagda hai. Lordship may issue notice to the opposite party. They may agree.
What are the injuries? Let us see first.
Injury, minor injury.
Where are they?
There.
Except FIR, you have not filed anything.
No.
What is this case?
As matter has been settled between the parties.
Maybe settled doesn't mean that you send a party.
Yeah, Lordship, I will file the
You have to
injury.
make out a case. What are the injuries? What are the weapon used?
Yes.
Nothing is written.
Yeah, Lordship, may issue notice. And next date, I will file the injury report.
No, you file first satisfied. It's not that it is a routine thing.
Okay,
FIR is registered, you come and quash it.
Yes, obliged Lord. I next date, I will file.
You have beaten black and blue. This is the allegation. You have used an iron rod. He fell down, become senseless. Thereafter, you kept on beating him.
But the allegation there, but
Whatever. Then you show me that the injuries are
I'll
simple
file
or
the
anything
injury.
else. You are satisfied after 1 week. You file the document. What is the stage, by the way? Charge sheet filed.
No, I just not filed.
What is the stage? You have an idea?
No, your lordship.
A charge sheet not in front. As per my instruction.
FIR allegation FIR allegation is very serious. Mundo Dipala level iron rod has been used, but injury report is required.
There is simple injury. I will file the injury report.
At least injury report is
Yes,
filed.
yes.
We'll see. Okay. Simply after 1 week or 2 weeks. Yes.
24.
24 year old Belgium matter. Petitioner was released on bail 4/12/2020. Enroll issued on 4/12/2024, your lordship. Page 27 সেটা reflect করছি।
Yes.
25.
May I please, your lordship. In this case, my lord, file a quashing of FIR, my lord. Quashing of FIR, my lord. I pray, my lord. My case is 307, my lord. Twice bail application rejected. I small prayer, my lord. Faster second of parity. Other questions are reduced.
307.
My lord.
Yes.
What are the allegation? Let us see.
Allegation समस्त आसिले पाडेले.
Have you applied for anticipatory bail?
Twice apply, my lord. Rejected. जब केवल गोटे केस थिला कॉलेज पढियाला सेति में रिजेक्ट।
Where is that order? Let us see.
Order, my
That order also you have not filed.
no, not filed. Number is mentioned.
Appreciate one thing. You have applied for executive.
My lord.
The coordinate bench has rejected.
My lord.
And today, if I pass any order without seeing that order, I may be sitting when I'm reverting that order or something of that sort.
Mention my number already mentioned.
But I need to see that order at least. Will you not file that?
Password, I will.
How can I see? Suppose he has said something. Without looking at it, I pass some order.
Password, my lord, I will submit.
Why have you filed like this then? This is very minimum thing.
Limited.
This is the kind of sharp practice you people are. This is completely sharp practice.
Sorry, my lord, for that.
You get order from some other court. You don't disclose that. Don't file it. And simply you come and innocently say that do this. I look at your face. I pass the order.
Mention.
Thereafter, it is found that the order is something else and this is something else.
BLP.
Where have you said that? No. I'll have to
mention. Man.
Where have you mentioned?
Certificate page 2, certificate is given.
Where have you said that what happened there?
My lord, page 2.
No, what happened in that bail application, that has not been mentioned. Only mentioned that 2 bail application, present petitioner earlier approached for this filing 2 bail application. A BLPL number 12113 of 2024, another one is 3930 of 2024, your lordship.
Withdraw it.
Thrice your mention.
I will not allow like this. This is very, because of the work pressure, we pass the order. And these are being misused.
Surrender only, I pray.
No.
Surrender.
Land Council for the petition seeks to withdraw the present petition to file a better one with better particulars and the relevant documents. With this liberty, petition is dismissed as withdrawn. Don't do that. This is very unfair. Yes.
26.
Nowadays, every order is within second you will get that order. Not filing that order means something, according to me. Can't you get it within a second in a mobile? You can get it. Why are you not filing it? That means there is something.
I will
serious.
Password, I will.
No. I will not allow this. You so casually you file it that nothing happens. And after all, you are seeking a relief which is not, you are not at all entitled.
Sorry, madam.
You are not at all entitled. If you want relief, at least you should be fair enough to the court. Come with the clean hands.
Fairly
then you get some indulgence.
I will fairly submit. Sorry, my lord. I will.
Okay, you file a fresh one. File a fresh one with all documents. Disclose it. Yes.
May I please ask? Here the prayer of the applicant is the quashing of the proceeding so far as the petitioner is concerned, my lord. Here charge sheet has been filed against me under section 66E, 67, 67A of Information Technology Act.
Yes.
Lordship may kindly see the charge sheet.
Yes.
Page number 26 against accused number 2.
You are accused number?
My name is not in the FIR.
No, it's all right. Charge sheet?
Charge sheet, Lordship may kindly see page 26.
Yes.
Krishna Chandra Sahu.
Okay. Let us come to the allegation.
Yes. Allegation is 66E, 67, 67A of IT Act. Against other accused persons, other allegations are there. My name doesn't find in the affair. The prosecutor, the allegation is the victim says that accused number 1 and 2, in connivance with each other, they kept physical relationship with him and took a video shot and made a viral of it. Allegation against me by under 161 statement by some persons that I was watching that video near Durgapur Chaka. That is the sole allegation against me by the witnesses. The victim doesn't know me. So here my humble submission before Lordship, kindly peruse 66E, 67.
Let us see the 161 statement which
yes. And there, another thing, I'm sorry, I'm taking Lordship to that pattern. So the person who has given 161 statement has contracted himself in 164. I'll point that out.
Let us see.
Yes, I'm taking Lordship.
And if you are only watching the...
yes, Miller. 20, page number 65.
65, huh?
Golekha Prusti.
65. Yes, read it.
The relevant paragraph. Golekha Prusti, last but 5. Hostel le thila bele, eha ghotila taha sehi coaching center re ଠାରୁ ବାପା ପଚାରିବାରେ ସେ ତାଙ୍କୁ ଧମକେଇଥିଲେ। ଆମେ ଏଇ ଭିଡିଓଟିକୁ ଦୁର୍ଗାପୁର କଲୋନୀର ଟୁନା ସାହୁଙ୍କ ମୋବାଇଲରୁ ଦେଖିଅଛୁ। ମୋର ଏହା ବୟାନ ଅଟେ। I am not Tuna Sahu. My name is not Tuna Sahu.
Where is your thing?
Krishna Chandra Sahu alias Tuna, present petitioner, Your Lordship.
Yes,
Krishna Chandra Sahu alias Tuna.
this is page 65. Lordship got it.
Yes.
Then Lordship see the 164 statement of this Golek Prushti.
Yes. Yes.
Page number 70. ନାଇଁ 70 ବି ସେଇ କହିଛନ୍ତି ଯେ ଆମେ ତା ମୋବାଇଲରେ ଦେଖିଥିଲୁ. Then how they contradicted themselves. Yes, 85.
You are Tuna Sahu.
Alias Krishna Sahu. Page 85. This is 164 of Prushti, Golek Prushti.
Yes.
I know the informant Sachra Marana of this case. I know the victim of this case. I do not know the accused persons of this case. The occurrence took place about 4 years back. One day at evening.
Examined, my lord and friend has filed the deposition copy of the 15 witnesses, Lordship. And 34 is there. And very much the name of the present prisoners have taken other witnesses. Yes, Lordship. One Golek Prushti, my lord and friend has already been read out.
See,
this is the statement of the victim.
Once the 64, page 64A, one of the witnesses says
that victim has also given statement, my lord.
But at this stage, now the most of the witnesses have been examined.
ସେମାନେ ପରେ ପରେ ଜଣା ଶୁଣଛୁ ଲୋକ ପଠାଇଥିଲେ ମୋ ମୋବାଇଲରେ ଭିଡିଓ ମଧ୍ୟ ଛାଇଥିଲେ ଆମ ଘର ପାଖ ଟୁନା ସାହୁ ଉକ୍ତ ଭିଡିଓକୁ ଦେଖି ସେଥିରେ ଆମ ଝିଅ ବର୍ଷାରାଣୀର ଥିବାର ଜାଣି ଆମକୁ କହିବାରେ ଆମେ ତାଙ୍କ ମୋବାଇଲରେ ଦେଖିଲୁ ଜାଣିପାରିଲୁ.
That is right.
I am not. My lord and friend has read out the one of the statement Golek Prushti, Lordship. Another statement is read Vijay Kumar Maharana and this Sulochana Maharana.
Let us come to the deposition. Forget about 161 now. Let us come to the deposition.
Lordship,
He has come because he is coming at very late stage.
But yes, your Lordship, that is there.
Lordship, kindly see deposition of the victim. What does the victim says? And how section 66 will be leveled against me? The language is very much clear. Who captures, who transmits.
From the present.
I have not captured, I have not transmitted. At best,
read it out where you see.
That 161 statement, Lordship. The other witnesses who have stated the name of the present petition, Lordship. Yes, your Lordship. Vijay Kumar Maharana, page 64.
Deposition, just see what are the allegations.
Deposition, Lordship, that's right.
Deposition of the victim, Lordship, may kindly see.
Okay,
I have given the copy.
Victim, any other evidence?
I have given the copy.
Have you read it or just now?
Yes, may Vijay Kumar Maharana, the father of the victim, Lordship, what stated, Lordship. ସେମାନେ ପରେ 10 ପଲାର ଅନେକ ଲୋକଙ୍କ ମୋବାଇଲ କୁ ସେଇ ଭିଡିଓ ମଧ୍ୟ ପଠାଇଥିଲେ ଆମ ଘର ପାଖ ଟୁନା ସାହୁ ଇଏ ତେନ୍ ପିଟିସନର ଉକ୍ତ ଭିଡିଓକୁ ଦେଖି ସେଥିରେ ଆମ ଝିଅ ବସାଣି ଥିବାର ଜାଣି ଆମକୁ କହିବାରେ ଆମେ ତାଙ୍କ ମୋବାଇଲ ଦେଖିଲା ଯେ ଆମ ଝିଅର ସମ୍ବେଦନ ଫଟୋ ଉଲ୍ଲଗ୍ନ ଅବସ୍ଥାରେ ପଠେଇ ଅଛି ବୋଲି
ଅଛି.
Yes, then has he transmitted?
Lordship, the present petitioner
rather he saw that and told the
I make them aware.
Yes, Lordship, that's right. Lordship, another statement, Lordship, the Golek Prushti has clearly stated, Lordship, Golek Prushti.
He has contradicted in 164.
Okay, read it.
Yes.
This is deposition you are reading.
No, Lordship, I am not reading the statement.
Has that witness have been examined?
Yes, yes.
That witness, Lordship, I have not verified whether Golek Prushti has been examined or what.
Yes, Golek Prushti has examined. Page number
85, my lord.
85,
Lordship.
Read it. Read it.
I know the informant, Sachra Maharana. I know the victim of this case. I do not proceed. Trial has commenced.
That is the reason I am not saying. Why have you come so late? You allowed the witnesses to be examined.
That is true. At least.
And I'll see so many witnesses are examined.
Yes.
Now at this
I am not objecting. I am not objecting process of trial.
I will issue
only so far as the petition is concerned.
I will not say because you came so late.
Yes.
I will not solve the ongoing trial like this. You should have come at this very.
Yes, he has come in belated stage.
And moreover, she evidences have come. And while exercising 482, can I?
And the witness has.
Can I?
No, absolutely not. And the Lordship can say the victim statement. He also
Whatever,
doesn't know.
can I appreciate the evidence which has come on record and acquit you or discharge you, whatever I.
No, I am not
Then
trying to acute. Lordship,
You allow the
notice.
trial to go on for such a long. So
Yes.
how many witnesses are there total?
Total, I do not know. 15 have been witness examined. 15
total witness.
34. Your Lordship. My lord and friend has
Then-
filed the charge sheet 34.
Then I can't keep on.
And till October 2024, 15 witnesses have been examined. In the meantime, 8 months will elapsed. 6 months will elapsed.
I'll just simply issue notice. Let us. Yes.
issue notice to the informant.
No.
Let them come. Yes. Why? Yes.
27.
27, the prayer is very innocuous, Your Lordship. Kindly glance for a moment, the prayer, Your Lordship.
May
Very.
please, my lord.
Looking for prayer for bail.
I would like to not press the case, my lord. As the accused person, the petitioner has already released by the IO.
What are you seeking?
I am seeking bail from my lordship, but the present petitioner has already released in bail by taking the aid of section 41 CRPC. The IO has already been released.
Then withdraw it.
Yes, yes.
The
I
counsel
know.
submits that the petition has become infected, then she seeks to withdraw the petition. Withdraw. Yes. Next.
29.
Please, Lordship.
Lordship, we are challenging the order of cognizance, my lord. My lord, here it's a only inform your lordship what had happened. My lord, the FIR story is that the complainant is a my lord, fruit seller or fruit distributor here in Odisha. The accused is a fruit seller from Bangalore. He accepts in the FIR that they have a long pending relationship. They have been getting money, my lord, as it happens in those things. My lord, there are some kind of credit which happens, could not be repaid back because of COVID. The allegation, my lord, is that I filed an FIR in Bangalore for those money which is not being paid to me. To serve the notice, I came with a police officer from Bangalore to Cuttack to serve him the notice. While the police officer was outside and the notice was being served, I abused him in filthy languages and threatened him. My lord, that's the entire allegation.
Quite natural.
My lord,
That's quite natural.
my lord, then I am prejudiced, my lord. My lord, if your lordships, my lord, if my lord,
Natural behavior.
my
You
lord,
have done it.
my lord, if a
Natural.
person from Bangalore, my lord, imagine this.
No, see the frustration. You came with a police to
Correct, my lord.
arrest.
But my lord,
Obviously, when he sees, he vented out.
yes, my lord.
Obviously.
No, my lord, may kindly imagine. I accept.
Will you settle the dispute?
No, my lord, I will come to it. My lord, just answering
tell
your
me you
lordship's
have-
query because my lord has fallen from your lordship. I'll just
Yes.
inform your lordship. I'll take whatever falls from your lordship. My lord, person from Bangalore comes with one police officer to Chhatra Bazaar in Cuttack. In front of people, he scolds. My lord, I am sure, being a citizen of Cuttack all my life, he would not have gone back, my lord. My lord, with all due respect, my lord.
But perhaps those people.
With all due respect, my lord, with folded hands.
Naturally. The other people have not acted naturally, but you have.
Now, my lord, may kindly see.
And issue notice, settle the dispute.
No, my lord, I don't have a problem.
Official-
I don't have a problem. my lord.
What happened to that Bangalore case you have registered against him?
But charge sheet is already charge sheet his file, my lord.
You settle both the dispute.
No, my lord,
That's a better idea.
My lord, I have no problem, my lord. I have no personal beef.
I will issue notice, let him come.
My lord.
We'll see then.
My lord, no problem.
Both the matters, because you have been in business.
My lord, if I honestly say, my lord, as an officer of the court, it is a civil dispute. I mean, both FIRs are a civil nature.
Wrongly file a case.
No, my lord,
he also filed. a case.
my lord, that's what I'm saying. I'm fairly saying before your lordship.
Bangalore, you use Bangalore police. He has used. What to do?
That could be a fair assessment, my lord. I must say, as an officer of the court, that may be a fair assessment.
Notice.
My lord.
Try and settle. the
My
issue.
lord, only that, my lord, I'll file a my lord, time petition, my lord, that may be considered, my lord. Here, my lord. Because already that's the
not to aggravate. Issue notice.
yes.
And shall I send it to mediation straight away?
My lord, as you lordship, otherwise let them appear, my lord. I'll also, in the meantime, once they appear, I'll also take instruction, my lord. Although I'll my lord, I should prevail over it.
By tomorrow, file
Yes.
the process by tomorrow, and we'll see. Huh? After I'll give you a date.
My lord, please.
So that both the Bangalore case will also be over. Come on, 7th, huh? 7th.
No, duplicate.
Yes.
But in the meantime, my lord, I have only filed.
Move application for.
I have only filed an IA for adjournment, my lord. That may be.
Yes.
That may be just.
Yes, you move application.
No.
Yes.
That may be mentioned, my lord.
7th for, yes.
Yes.
Application.
Duplicate.
And file the process, huh, immediately. 20, 30?
Lord, here the petitioner is challenging initiation of DB proceeding, my lord, filed under section 12 of Protection of Women from Domestic Violence Act. Prior to filing of this DB case, my lord, at the instance of petitioner, an application under section 13 of Hindu marriage was filed. I have annexed
It is
that.
arising out of a DB case.
My lord.
But you have not implemented the complainant.
My lord, OP number 1.
Huh? Okay, yes. Issue notice.
Well, in that effect, there is absolutely no allegation in respect of father-in-law, mother-in-law. I have annexure 1, that is the DB miscase, my lord. He has not uttered a single word in respect of 2
What
and
is he
3.
asking in the DB proceeding?
My lord, this DB, she is asking interim maintenance of rupees 12,000 and litigation cost of rupees 30,000.
Okay.
That much.
Yes. Issue notice. Yes, next.
No, my lord, proceeding at the nascent
Why have you
stage.
implemented Adjournment then, petitioner? Why have you done?
My lord, in the
That's the strategically you committed a mistake.
my lord,
By making
आज
husband
because
number 1.
my
You
lord,
should have see mother-in-law, father-in-law could have approached this court. I would have
my lord,
passed
I
an
do
order.
concede only on the ground that decree of divorce has already been passed and quantum
That's why I'm he is asking for maintenance.
quantum of
Not the
maintenance.
husband.
Quantum of maintenance also already been directed to pay rupees 12 lakh towards permanent alimony.
Where is that?
That is there.
Page 30, I think that's
My lord, annexure 2, my lord.
Are you paying?
25 crores.
25.
Yes.
Are you paying the maintenance?
Subject to payment of 12 lakhs. The
My
rest
lord,
wife towards a permanent alimony.
order has been passed.
Are you paying or not?
My lord, in fact, he has, what I have instructed, he is going to approach before this honorable court.
No. Then I'll ask you. You must pay the maintenance.
That I will take instruction and I
Simply
will
issue notice. Okay.
I will stay of the proceeding because father and mother.
See, it's a maintenance cases. How can I say? You make a statement that you are paying maintenance, then I'll do it.
That I will
Despite
tell
the
you.
fact that it is an order, you are paying not paying maintenance to the wife.
That part I
And you
will.
want to say, how can I you should say like this? After all, it's a case of vagrancy. You can't do that. Yes.
No, notice.
I'll issue notice. Yes. Issue notice. File the requisites. Letter come. Yes.
31 does see.
31 my lord, I prefer not short adjournment.
Adjournment.
Yeah.
Already paid.
Yes. 33.
32.
Order taking cognizance on the challenge. 2016 law cognizance order ta challenge hochi 447 294 506 34 IP issue.
No is there. Pass over. Yes.
33.
Rejection of my application under section 311 of CRPC. The order is challenged. Here, what happened during pendency of the proceeding? The victim has already been examined. Now, I want to some questions because in the meanwhile, compromise has been set. The matter has been compromised between the parties, and I am relying on a decision referred by a lordship that in the meanwhile, the victim has more than similar case, 10 years similar case.
Use the mic. Huh?
FIR is lodged in the year 2014. By that time, victim was 17 years old. And in the meanwhile, 9 years has been passed.
You're seeking
Only recall of victim.
which witness?
Victim, my lord. Witness number 4.
Huh? PW?
PW 4, my lord.
Four.
PW 4.
She's the victim.
My lord, my lord. And by the time FIR is lodged in the year 2014, she was 17 years. In the meanwhile, 10 years has been passed. She is more than 27 years. My lord. Only victim, my lord.
What is the, where from I get that she is not a minor now?
My lord.
Where from I get?
Lordship, kindly see the annexed. Annexure 2 is the recall petition. Annexure 1 is the FIR.
Yes.
Annexure 1 is the FIR 366, 376. Subsequently, charge sheet submitted 376 2N, page 12. Sunita Harijan, 17 years of age.
2014.
My
FIR is 2014. That time what was the age?
17 miles. Sunita Harijan, page 12. Sunita Harijan.
10 years, 17. Where is that age?
More Jio Sunita Harijan, 4th line, my lord. Medical କାର୍ଯ୍ୟରେ କୁଲି କାମ କରିବା କିଛି ମାସ 17 ବର୍ଷ।
Now you have settled.
It has been settled.
Settling in the sense you are staying together. What?
That not staying together.
Where have you said that you have settled?
Your lordship, kindly see the questions.
Because why I allowed this, I remember it. Then because they have also settled because of the Supreme Court Ramji Lal. I could not have quashed. So therefore I said that you move 311, bring her at least, you will make a statement, then you are coming out.
Your lordship, kindly see the questions, whether you want to, you have any allegation against the persons.
Where have you said that you have settled?
Further process. So far this recall petition that has not been stated. In recall petition also they have not stated about
the petition also you have not stated.
And petition also I have not stated. Lordship may permit me to file affidavit.
File. I will issue notice on it.
Today is the, may I prepare only for adjournment application.
See, you want no. Why should I pass it like this? You file a incomplete petition.
No.
Minimum thing you don't write, and you need everything.
That is my mistake, my lord. But it has been settled. It has been settled, my lord.
It has small things.
Yes,
why are you doing all this?
This has been settled.
No. I'll see. The stay orders are not routine thing.
Then I am not made party victim, your lordship.
Neither you made the victim party.
Yes.
Nor you made a statement that you have settled with the court. Just see the petition.
Yes.
In this petition, who will give you relief?
And
in there, you tell me.
Today morning, I have seen.
This is High Court. At least don't reduce the High Court.
Not a single word about the settlement. Like even in 311 petition also that is not there.
Then
that is there, man.
Don't reduce the proceeding of the High Court to this level, please.
Not that matter, because matter has already been settled, and today this.
Where have you said a single sentence where you anywhere you
I'll file affidavit. Of both the parties, I'll file affidavit.
The word settle, you send it.
I'll file the affidavit. Your lordship, today the case is posted for argument.
There is a bar, 35, 3 bar.
Yes. Today the case is posted for argument. That is why I am seeking for adjournment.
I will not give. Let them suffer. Then only you will understand how to prepare a petition at least. Yes, simply adjourn to next week.
No, your lordship, I issue notice. I'll make a.
To whom I will issue notice? You have not even implicated the parties.
Victim as a party. Paperless, man. I'll file a consolidated cost
petition is like that.
I'll file a consolidated cost.
You file it, then I'll take it next week. Next week. Keep it next week. Please don't do that. At least you should have written it. I have settled the dispute. On that ground, I would have.
That has been badly drafted.
Yes.
34. Belgium matter.
Yes.
Police bail on 26 January 2019.
Yes.
And the NPW was issued 29/8/2023. The NPW order on page 26.
26.
26.
Leave the dates. Huh? Take the dates at NVW issued on 2023. 500 each. 500 each. Okay. Yes. Next.
35. Petitioner has only limited period to
35. 35.
Yes. 35. Yes. 35.
Yes.
For 7 missing the for 7
I mean, pardon, my lord, 35 is of mine. Here I have filed for case quashing of the entire proceeding. Grounds has taken that they are married and living together, and I have also implemented to the informant as party annexure 4 re Arya Samadar
I
marriage.
issue notice, sir. I issue notice. Let them come. They settle the dispute. Yes, issue notice.
May pray, my lord, for interim relief.
He will move application for adjournment. Okay, yes.
36.
See, I am praying for the disposal of the GR case within a limited case. Yes, sir.
Who are you accused?
I am not the accused, Lordship. Actually, I have a petrol pump. One day, for the adulteration, one tanker was there.
Who are you? Are you?
I am the owner of the petrol pump.
No, in
But
the
accused-
CR case, whether you are accused
I am
or
not the
informant,
accused. My manager is accused.
then who are you?
Himself.
Then how can you ask for?
Because due to this only, collector is not renewing my license, Lordship.
That's a different story. But
My only limited prayer is to dispose the.
yes, I understand it.
Yes.
But neither you are the informant, nor you are accused. You are a stranger to the
But
proceeding. And you are asking for.
I'm not stranger. My petrol pump is, Lordship, it is written that.
Maybe.
Yes.
You neither the accused is made party, nor the informant is made party. A third party who has nothing to do files a petition asking for subdirection. How can it be done?
Also, in division bench, when this case was there for the renewal of the license by the direction to the collector, there also honorable court said that up to how.
Try to appreciate. At least in a criminal proceeding, the accused informant has a right to do something. A stranger moves an application for some direction without pleading the informant or the accused. Implead them.
Yes, sir. I will implement the CS Lordship.
At least the informant has a right to come. Your manager, the manager could have filed a petition. You are no one. Fortnight Petroleum.
Yes.
Who is Fortnight Petroleum? A third party comes and takes an order and goes.
That only my license has been cancelled, Lordship. Due to that proceeding only.
Withdraw it and file a proper petition.
No, Lordship, I will only make the CSO as a party. Who has given the information?
I don't know what you will do, but this petition is completely frivolous. You have nothing to do with the criminal case. You are a complete stranger to the proceeding. And asking for a direction for early disposal.
I am affecting due to this proceeding only.
Affecting everybody is affecting in this society. Doesn't mean that.
This is the related to the adulteration of my petrol pump.
I'll just simply either adjourn it, do whatever you want to do, or otherwise.
Just keep it to next week. I will.
Not next week. Please it after 3 weeks. Sir. Yes.
37.
Please it after 4 weeks.
The charge sheet filed under section 147, 140, 307, 140, 294, 323, 3 and 507 are cases. Among this, except 307, 506.
NBW issued. Yes. Yes, Mr. Vishwal. Just see, tell me the dates.
NBW was issued as he declared as absconder.
He was absconder.
That's it.
Charge sheet was filed in the present case on. When the charge sheet was filed?
Charge sheet on 30th January 2023.
Filed, so
30th December. 30th December 2023.
During the petition as an absconder. Thereafter, the NBW has been issued against him on 13 December 2023 is the NBW.
Yeah.
I'm talking about charge sheet.
Charge sheet is the 30 December 2020. NBW was issued on 13/12.
Just see the prayer. See the prayer.
2020.
See the prayer. Was the NBW order dated 13/12/2023 passed by so and so? I am asking when the charge sheet is filed.
Charge sheet filed, Lordship. He received
I think at least this much assistance you give. At 2 dates you can't give.
30.
When the charge sheet is filed.
30 to December 2020.
When the NBW issued? Same day.
13. NBW 13. 13. 13.
Lordship, that is the page 19. Page number 19 and 12. He was earlier released on interim bail by December 4, BNPL 14036, 2021. That bail order was 25/11/2021. After obtaining the interim bail, he did not appear, he absconded.
That's not appear due to my father's name is wrongly reflected, the police has not accepted. But that effect, individual issue.
Please wait, I'll read it. Wait, I'll find it. What is it? What it means? Vishal Vera. Yes. Yes. चार्जशीट फाइल ऑन पीडीसी 12/2023 ठीक है showing the petitioner is an absconder. Although the petitioner was on an interim bail, but he did not appear. Is a consequence of which the NBW has been issued. The NBW will go 500 conduct. Yes, next.
38. Please, Your Lordship. I'm in virtual mode. Works.
Yes.
I'm in virtual mode. Mulats, in this case, the petitioners have approached this honorable court seeking quashing of the FIR, the charge sheet, and the entire consequential criminal proceeding against this petitioner, who are the offense as placed in their name in the charge sheet.
I'll issue notice. Matrimonial dispute. I'll issue notice.
Yes.
498.
My lords, one more thing. Due to inadvertent error, the informant has not been impleaded as a party. I seek leave to implead the informant as a party and submit the.
Seek leave of the court to implead the informant only victim.
Submit the process as well, my lords.
Issue notice to the newly implemented opposite party number 2, written would also. Yes.
My lords, may I pray one more thing, my lords? Since this is a dispute arising out of matrimonial, and there are multiple disputes which is pending before this honorable court as well as before the court below, between both the litigating spouse. So, it would be in the interest of justice if the parties be directed to appear before the mediation center.
No, I will not be a court can't be a party for settlement. If you are settled, you bring them.
If the honorable court will direct the party to appear before the mediation center either in Sambalpur or High Court.
First of all, you have not impleaded the.
Yes, that was an error. I'll clear it. Yes, Your Lord.
Take out notice. Next man. Take out notice. Yes.
Much obliged, my lord. Much obliged.
Lordship, I am filing a written note of submission, and this is the matter relating to the dispute under PMLA, wherein I had submitted that sanction for prosecution is needed under section 197(1) of CRPC, and unless sanction is obtained, the order of cognizance is valid in law.
Yes.
And my Lordship on the last date made a query regarding whether sanction had been obtained for the scheduled offense. And my learned friend was to take instruction on that point.
Yeah, admittedly, FIR has been registered. And offense under the PMLA is a separate and independent. So also time we see the trial court order.
Yes.
It starts from page 32 now. So Lordship may turn to the next page.
Yes. Yes.
Srimati Manni Kumari Krishna, 4, 5, 6, 7, 8, 9th line from bottom. Srimati Manni Kumari Krishna, A1, and accused Vijay Ketan Sahu, A4.
Yes.
And others said a vigilance inquiry was initiated and simultaneous searches were conducted on 29/8/2018. and it was ascertained that the accused Nalini Kumar Mishra and the spouse accused Vijay Kumar Chetan Sahu acquired 6 number of plots in different modes of Khurda district, purchased flats and constructed houses at Madhusudan Nagar, flat at Grand so and so, so and so. Then the document come to the next page. The judgment of that Vibhu Prasad Acharya has been quoted in the last 3 lines. The decision relied upon by the accused persons of the Honorable Apex Court in criminal appeal number so and so in case of Directorate of Enforcement versus Vibhu Prasad Acharya etc. is not applicable to the facts and circumstances of the present case. On these above grounds, that so and so. Then your Lordship may come to the page 36.
Yes.
Last subparameter.
Yes.
In the same case, Honorable Court held that the protection under section 197 CRPC has certain limits and is available only when the alleged act done by the public servant is reasonably connected with the discharge of his official duty and not merely a clock for doing the objectionable act. Section 197 CRPC does not get immediately attracted on institution of the complaint case. And trial court has said, here, my lord, he has, you will also kindly see the complaint. He has page 4, my lord.
What about schedule offense?
Schedule offense FIR has been registered, my lord.
No, the question.
Investigating the schedule
No,
offense.
the question is, if in the schedule offense, if you have taken sanction,
No, my lord, under the
ED
once FIR is not registered, ED gets power to investigate high complaint. ED after investigation found that yes, he has proceeds of crime, which he has not done in his official duty. He has collected huge amount, deposited cash in the bank.
but see, the issue is now, I don't know, that has to be addressed.
Yeah, no.
In the one being,
Address in the Supreme Court judgment.
in one wing of the state,
Yeah.
prosecute him in the schedule offense, taking sanction, saying that it is a part of official duty.
No,
And
they are taking sanction for the disproportionate asset.
so 19,
Yes.
yes,
Here, my lord, we have investigated that the money here.
but that flows, the proceeds of crime flows from that offense only.
Schedule offense, but
Certainly.
here, my lord, our investigation is to satisfy what is his source of income.
No, that you can do. What I'm trying to ask you is, if you say that while having his official duty, he has done some crime, and for that you have took sanction and prosecuting, no problem. And this proceeding which you have initiated, PMLA proceeding, he is a offshoot of that. Offshoot of that, obviously. Offshoot of that. Then if you, can you in this proceeding say that no, it is not official duty?
Your Lordship, kindly see the judgment of that Vibhu Prasad Acharya.
Yes, show me that.
There on the records, Lordship.
It's there.
It's there in the records, filed it.
Judgments happen. Yes.
The facts of that.
Vibhu is there. Which paragraph you are reading?
Yes, my lord. Your Lordship, first, my lord, kindly see paragraph 6. Paragraph 5, my lord, that 197 has been quoted.
Yes, 6. Let us see. Yes.
Paragraph 6.
Object of
The
197.
object of section 197(1) must be considered here. The object is to protect the public servant from prosecution. It ensures that the public servant are not prosecuted for anything they do in discharge of their duties, my lord. Suppose I being an officer, my lord, I allotted some land to somebody while doing my official duty illegally. There, my lord, sanction is required. Suppose I collected some money, I committed a murder. Can sanction is required?
If that is the schedule offense and if you have taken sanction, it is obligatory here.
My lord,
That's
no,
the
no,
question.
my lord, kindly see
Let
this
us-
judgment.
That's my view. I don't know. Maybe I'm
And
correct.
that's why trial court has taken note of this judgment.
Yes, let us see. Let us go through this.
It
This
ensures that
provision.
the public servants are not prosecuted for anything they do in discharge of their duties. This provision is for the protection of honest and sincere officers. However, the protection is not unqualified. they can be prosecuted with a previous sanction from the appropriate government. The expression to have been committed by him while acting purporting to act in discharge of his official duty has been judicially interpreted. A bench of 3 honorable judges of this court in case of Center for Public Interest Litigation versus Union of India and so and so. This protection has certain limits and is available only when the alleged act done by the public servant is reasonably connected with the discharge of his official duty and is not merely clause for doing the objectionable act. If in doing his official duty he acted in excess of his duty, but there is a reasonable connection between the act and the performance of the official duty, the excess will not be a sufficient ground to deprive the public servant from.
In this case, what is the schedule offense?
Here, Milord, here allegation was he allotted certain lands illegally to a company.
What is the schedule offense?
In this case, Milord, in our case.
No, in this.
Here was the
Bibu.
Bibu Prasad Acharya, my lord, 13(1)(d). 13(1)(d) of the Prevention of Corruption Act.
The ultimate, what is the finding?
Ultimately, here court passed because here allegation was he allotted certain lands illegally to a company. So while allotting the land, so court said yes, he was doing his official duty, he allotted illegally or not, so sanctioned. But here, my lord, he has collected deposited huge cash deposit in his bank. I have given your lordship, can you see that in my complaint?
Yes.
That huge cash amount has been deposited without in the account.
Where is the complaint?
I have just handed over to them.
Yes. No. Yes.
Lordship, kindly see, turn to page 4.
You are Nalini?
Nalini Kumar Pushti.
Nalini Pushti Vijay. Yes.
Below page 4. We have given in our complaint below the immovable properties, page 4, 5, and 6. He has acquired property worth rupees 2,82,42,212. Then the cash deposit below table.
What was their position as Nalini? What was he?
Milord, originally
Financial advisor, come chief accounts officer.
Now chief accounts originally for us.
Vijay Ketan Sahu is Tahsildar.
At present, he is a deputy secretary.
At page 3.
Yes.
Paragraph
I got it.
He joined service as is an Odisha Finance Service.
I got it.
Yes. The person is on her to prove what is her source of income. And yesterday, below the judgment has come on this PCI. Yesterday, judgment has come. So, Honorable Apex Court said, no, it must be left to the trial.
No, that you are correct. The only question which is troubling me is even that judgment is not answering.
Yeah, I understand. I could have exceeded, Milord. But here, Milord, FIR has been registered. Your lordship wrote, once FIR registered, Milord. Yes, Milord. And once we file the complaint, so thereafter, Milord, this proceeding become independent. Milord, this has been dealt with.
Do you have any answer to that question? If in the schedule offense, if you have taken sanction, treating him as
I cannot say, Milord.
because for him state.
Yes, Milord. No.
This being a state or that being a state.
No, not Milord. Here, Milord, the enforcement directorate is a separate investigating agency.
But are you not the state?
Yes, we are state.
For an accused, who are you?
Yes, Milord.
You are the prosecuting agency.
Yes, Milord.
That's all. But one prosecuting agency is taking sanction, saying that you are a government servant. And the other prosecuting agency, which is an offshoot of the earlier case, schedule offense, says that you are not government servant. Is it possible?
I am not saying you know,
that is troubling.
it's not a government servant. I am not saying.
No, sanction is not.
Sanction is not required because here, Milord, my submission is here she accumulated the wealth, Milord.
By using his official position.
Not, Milord, by official position.
What in course of the official?
In course of office, not by using official position.
Let us see the complaint now.
Yes, Milord, I handed over the complaint.
Lordship, 1 minute, Lordship, may I just one sentence? What is the offense? The offense can only be committed by a public servant. It cannot be committed by any other person.
Therefore,
And what?
19 section.
Yes, yes, Lordship, yes.
That is where
Yes,
I'm stuck.
yes.
That is where I'm
Yes.
stuck.
Yes, and may I hand over to Lordship the order passed by the Honorable
Any direct, just see this, I'll just
Lordship.
want to know.
May I hand over to Lordship the order?
I'll also look it. Can we get some
Yes.
light on this?
Your Lordship, next straight come to paragraph 21.
21, yes, under 21.
Judgment or take a
A
reference.
significant ground.
SLP criminal number 6185 of 2023. Kali eight.
Aye. SLP criminal.
Number 6185 of 2023.
Aye.
Pradeep.
21. Here the interesting question was raised. When schedule offence was committed, PMLA Act was not in force. Court said no, it should be left to the trial court. Your Lordship, kindly see paragraph.
Again, it is again jurisdiction.
That question is separate, different.
When offence was committed under PCF, when the FIR was registered, PMLA Act was not there. So on that ground it was challenged. PMLA Act was not a significant ground raised by the appellant pertains to the nature of alleged offence under the PMLA. The appellant has contended that the alleged acts do not constitute an offence under PMLA. PCF, when the FIR was registered, PMLA Act was not there.
Yes.
Therefore,
So
they say
that-
that,
that-
that's
so-
there.
So here also, my lord, here schedule offence FIR has been registered, my lord.
Yes.
May I hand over to Lordship?
I'll put it for some other day. Because
Lordship,
I
may
want to
kindly-
just.
Lordship,
I-
1 minute, Lordship. Lordship, may kindly
It's not
see
there, then I have
the
to
order
read
passed
it.
by the Honorable High Court of Delhi in P. Chidambaram's case, wherein the similar challenge, as in this case, is made. The similar challenge has been made.
SLB was filed against it. What happened?
No, SLP has not been
No, not
filed.
filed, I guess.
Which case, sir? Please take about the-
I can tell you the AR name also.
CR LMC 8996 of 2024, 8996 of
SLP. This was
2024
challenge. This
in
was
the
challenge.
High Court of Delhi.
This was challenge.
Then I will verify. Lordship.
Verify.
Okay, Lordship may keep that as Lordship is adjourning. Lordship may kindly grant me permission to file an application for adjournment as the case is posted for framing of charge. I am challenging the maintainability of the proceeding. The order of cognizance is bad in law.
Discharge application has been rejected.
Rejected, but the maintainability is challenged on the ground that cognizance is bad in law. Lordship may kindly see the Honorable High Court has also granted stay. Delhi. Stay of the further proceeding, last para. Similar challenge is made. Taking the Vivu Prasad Acharya's case.
Yeah, there is similar challenge, but the facts are completely different.
No, facts are not different. He was also prosecuted for the offence under section 13(1)(d) of the Prevention of Corruption Act, Maxis case.
This, have you seen the Delhi High Court order?
देखिए आगे मते किंतु
Para 5, just see.
Just yesterday's judgment from paragraph 21 to 36 are also kindly taken.
No, but that doesn't answer the question.
Below that answers everything. Under PMLA, that this judgment answers everything.
PMLA you can maintain. Who says? I am saying PMLA you can do it.
Yes.
Can you proceed without 197? That's the question.
Yes, Milord.
That's the answer. It. If you have taken 19 sanction
Milord,
for PC Act.
I cannot say whether 19 permits sanction has been taken.
It is obviously.
I have not investigated.
No. See this.
Once FIR is registered, Milord,
You have jurisdiction. You have jurisdiction. Fine. But cognizance can be taken by PMLA court without 197 or not. That's the question.
Yes, Milord.
Having taken 19 sanction for schedule offence, can you say 197 is not applicable? This is the question.
Yes.
And perhaps to some extent, P. Chidambaram is answering. Para 5, just see para 5.
Check up and I think that
Para 5 is to some extent it is answered. Very specifically answered. In the present case, the petitioner being, just read, I am reading it. Petitioner being a public servant and the commission of offence by him while in public servant not being in dispute, the challenge of the legality of the order of cognizance and continuation of the proceeding for want of sanction in the light of allegation level in the prosecution complaint would require further consideration. So therefore, this stay.
Here, Lord, I think that D. Acharya has been also taken note.
Yes,
of that.
after taking note, the court passed this.
Here, Lord.
Okay, release the matter from show. In the meantime, petitioner is granted liberty to move application for checking an adjournment. Please take. Yes.
Lordship.
Answer that. I want to see direct judgment. If you don't have.
Your Lordship is to interpret that Acharya judgment and yesterday judgment.
Acharya judgment has said that 197 is required.
Required.
Because the official functions.
Why? Suppose he has done something, he has been doing his official duty. The facts have been detailed in that.
But then in every case, while considering 197, the court has to apply mind whether it is official duty or not official.
Lordship,
If the case, if he would not have been a public servant and a private person, that's just you have taken sanction, 19 sanction.
Lordship,
you have no escape.
That we have to also check up.
You check it up. You check it up.
Lordship, in Bibu Prasad Acharya's case, as my learned friend submitted, there was an allotment of a land. And it is stated that 13(1)(d) is the offence, and it is stated that the petitioner committed criminal misconduct by obtaining for himself illegal gratification. By my learned friends, by my learned.
No, what he's trying to say is Bibu Prasad court has applied mind and said that it is official duty. If it was not required in 197, what was necessary to do it?
Lordship,
That's what he says.
13.
He had accumulated disproportionate asset. Now burden is on him to show. I have given in my.
That's why I don't dispute that.
Income tax return, my lord, 14 lakhs or more. He has properties, my lord, more than 3 crore. So burden is on him under section 24 to show from where he got it. So it is not in the official duty. In Bibu Prasad Acharya, there was clear allegation that he allotted land and taken gratification. Here there is no such allegation, my lord.
Here the offence itself is such that it cannot be committed by a non-public servant. The offence itself speaks that. While in office.
There is no doubt about the fact that you are not a public servant. That's not the issue. The issue is the act complaint in the complaint under section 44 is relatable to the official duty or not.
Yes, absolutely, absolutely.
It is not relatable to the official duty.
Yes.
So independently court has to apply mind while deciding 44.
Yes, I agree.
44 complaint you see whether the act complaint against you under 44 is relatable to official duty or not. Has to be independently leaving apart 19 and all.
That I will answer as your lordship has adjourned.
That you have to answer.
Yes.
He says that independently.
Yes, I will answer.
In Bibu Prasad, court has independently applied mind.
Yes, I will.
He says that you apply independently mind, whether it is relatable to official duty.
I will. I will. And
so
I think
fact you have to consider.
Lordship, I think in Jagannath Sadri's case also, where the offence is similar, the similar challenge has also been made. I will also
please
take out the decision of that case. Similar challenge has been made where the offence is same. But throughout the contrary challenges
case
are
is
being
very
made.
simple.
Yes, the case is same. That is also disproportionate.
44 complaint you see independently related to the
and my learned friend says here
197 million.
My learned friend says that I am few crores. In that case, thousands of crores.
But he says if that was not the case, if independently it's not required.
Yes,
you have to take action.
I will.
Why Bibu Prasad has exercised?
I will bring to you.
Suppose we could have alleged that while she was in office, while doing something, she has taken gratification, then things could have been sanction is required. But here this is not the case. Here your lordship is to see now what is he himself has filed the income tax not showing her income in last 4-5 years, 14 lakhs. Whereas the property accumulated is more than 300 crore. So she has to satisfy.
Then if I
300
agree with
नहीं
you,
आएगा
then in all TA cases,
cases
100
100 to
Not in all DA cases. It depends upon whether FIR and the complaint. Not in all cases. Not on all cases.
on facts to facts.
On it has to be on fact. That's why yesterday's judgment is very clear.
I'll read that.
Yes.
Thank you. Thank you. Thank you. Yes.
Challenging the order passed by the courts below merit, rejecting my application filed under 457. The petitioner has filed the present criminal miscase file. Petitioner is a licensee under Explosive Act since long, my lord. And
are you the accused?
Yes, my lord. I have been taken as an accused. My lord, here my license is continuing and it's valid till date also. My lord, FIR was lodged in the year 2023 for offences under section 286 by 34, read with section 345 of Explosive Substances Act on the allegation that I have kept a machine by means of which I have also making that what is called fire crackers. Well, that is Sonfuta Kajuda. That I was preparing. I have purchased it all from others, kept it in my godam, which I have got license, and I have kept a machine with me.
Yeah.
That machine was seized, and my lord, I have also been released on bail. I filed after completion of the investigation, I filed an application. The machine I may not use, but if it will be in the Malkhana, it will be damaged.
What was the reply of IO?
IO has nothing, has not said anything.
I'll issue notice, let us see.
But the courts below has observed that if I will take the same, ownership is not doubted, and nobody is claiming, no counterclaim, nothing is there.
But it may be misused.
Yes. Well, what I pray, it may be released, it may be sealed. If I break the seal.
Let the IO be.
Otherwise, it will be unnecessary damage there in the.
Yes. Notice.
My appearance.
Mr. Vishal accept notice. And seeks time to file status report. To file a report. Seek instruction from the IO.
Yes.
What he says is, let it be released. The only apprehension that he may misuse it, and for that, whatever condition
That is
you
the
want,
observation of the court.
whatever condition you want, that condition.
Any
will be-
condition, my lord, I am ready.
Yes. Yes.
What do you do?
May it please, my lords. If the petitioner challenges the order dated 22/1/2025 passed by learned special CBI.
Yes.
Lordship, हम यहाँ पर Mr. Sarthak Naik praying for possible.
Yes.
He is for the CBI, counsel for the CBI, my lords.
हम यहाँ पर Mr. Naik praying for possible.
Password.
Yes.
43.
In the order rejecting my petition on 311 CRPC on the ground that since no specific question has been made in my petition, on that ground only they have rejected. May I pray one thing, you know, the Lordship directs me, I file a petition again, once again, before the trial court, so
Which
that
petition?
by.
When counsel for the petitioner speaks to in this petition is said the order dated 17/1/2025 passed by JMFC bracket LR Bhubaneswar in 1cc case number 2265 of 2020, whereby his application under section 311 CRPC for seeking recall of Petition 1 has been turned down. The only ground of rejection, as reflecting from the impugn order, is that the petitioner has not formulated the proposed questionnaires. Let the counsel for the petitioner seeks to withdraw the present petition to move a fresh application under section 311 CRPC. The prayer is allowed. The petitioner is granted liberty to move fresh application under 311 CRPC. If such application includes, center we consider on its merit. It is made clear that in the pretext of moving the application under 311 CRPC, petitioner shall not cause delay in the proceeding of the trial. Yes.
What do you go?
If it is a peculiar case, allegations are under section 376(2)(L) and other things. Petitioner is in love with the respondent, OP number 3, but his father was, her father was not in favor of that, for which he wants to keep her within his control. But unable to, when he failed to do that, thereafter he filed the.
Let us see the allegation first of all.
My lord, allegation, your lordship may kindly turn to page charge sheet, page 26.
Yes.
Page 26 during entire investigation. Entire investigation and analysis of 164 CRPC statement of the victim denied the regarding sexual assault. As the victim denied regarding sexual assault on her, being unaware, her parents refused to take her GMA, for which she was produced before the CWC Deogarh, and as per order, she was sent to CCI Deogarh for safe custody. While the investigation is going on, Sri P. Mahapatra, so and so supervised the investigation of the case and declared it is a true case under section 12 of POCSO Act.
What is your name? Gangadhar.
Gangadhar.
Yes.
Sahu. Accordingly, notice under section 41A of CRPC has been served on the accused Gangadhar Sahu after explaining the terms and conditions. But during the
No, come to the page 26 para the third. On 19/4/2022.
On
Read that
19/4/2022, victim Karisma Dhar was produced before the additional district and session judge Deogarh as per the order of the Honorable SDJM recorded her statement 164 CRPC in which she denied about sexual assault. But as the victim once again gave statement on 13/7/2022, and her statement 161 as well as on audio-visual manner recorded accordingly. On 15/7/22, requisition has been placed DCPO Deoghar to verify the mental statement of the victim, Karishma.
As per the order of the
Yes.
victim.
And subsequently, yes.
For
As per
verification
the
of-
order of the victim, so and so has been, my lord,
Subsequently, once again sent to the court.
my lord, she has given.
No.
Yes.
Read it.
Yes.
Recording of the statement 164.
164. And
This time,
I
victim
stated
stated about the
my lord,
sexual.
that's what I want to place before your lordship. 3 to 4 times different statements are there. She is in love with petitioner. She wants to marry the
But the
petitioner.
fact remains, there is an 164 statement
My lord,
where specific allegations are made.
My lord, 164 statement, no allegation has been made. Thereafter, 164 statement, allegation has been made. My lord, that's what I am placing before
But
your
can
lordship.
I go into all
My
this?
lord, my lord, may I submit? That can be, my lord, sorted out. If your lordship protect me, I will marry her.
No,
Because
all these things are how court can direct.
Well,
You
no,
marry and come and tell me.
only my lord, your lordship may protect me because he is still now staying in the CWC, in a Swadhar home.
Just
She
see,
is not,
the problem is there is some mental problem. The
not
mental problem.
actually, she is not a mental patient because of this
This is
situation.
what the record says.
My lord, because of this situation,
Maybe created by you.
not by me, my lord, because by the father of the victim, because he was.
Where from I'll get all these things?
Because your lordship may kindly see the FIR first story.
The first
FIR story.
These are the, is the 376.
Yes, my lord, that is true. I am what I want to save the both of them. Your lordship.
Why have you not applied for bail?
My lord, bail 376, who will give me bail? Once allegations is under 376.
In a 482 petition, you can ask
My
for
lord,
it.
because
You will not
my lord, I want a protection so that I will go and marry her, so that everything will be fine.
I'll just simply urge it to do it and come. The POCSO is there and everything is there. I can't
Right now, my lord, she is a major.
See the
She is a major.
See the position of this girl. I don't know what kind of trauma she is undergoing.
May I suggest both of them, because she is now staying in the Swadhar home. She is not staying with the parents because parents are also tortured her. For which she is staying.
So just see the trauma of this girl.
Yes.
See, neither you have supported,
no,
not the parents.
My lord, I am.
Where will she go?
My lord, I am ready to support her, but for this case, I am not in a position. Your lordship may also see my predicament.
Where have you in the petition you say that you will get married?
Yes.
And pleading you have said.
Yes, I have stated. I have stated, my lord. My lord, that petitioner wanted to marry her.
Where, which paragraph, madam?
Page 5, para 6.
Yes.
Petitioner wanted to marry her since at present she is more than 18 years old and wanted to have a decent married life. But for this case, the marriage between them is not possible since police is searching for them, for him. If the entire fact will be taken together, it can be concluded that due to the ill feeling of the parents, that is the informant as his wife, the petitioner has been tagged to the case, although he and the victim are in
Yes,
law.
what do you say? There is a specific pleading that she will marry. He will marry.
Let them come before this.
No, what she says is protect me so that I'll marry. At least just see the practical side of it. The girl is now rejected by the family. Okay, her own parents. At least the only hope is this boy. And if you don't protect this boy, then this boy will be taken into custody. Then the scope of marriage also goes. Then what will happen to the girl? You think in that perspective. Forget about the crime and whatever. In that perspective, you think if you want to save the victim, this is the only way we can help her. Because she is making a very specific statement in the this thing. I'll record this statement and simply protect her for some time. Let us see how he is reacting.
Yes.
Right. Petitioner is one of the accused. And a petitioner is the accused in Deoghar PS case number 328 of 2022. Allegation against the petitioner is shown. The reading from the charge sheet reveals that the petitioner initially, the victim initially, refused to record her statement under 164 CRPC. However, subsequently, she has deposed against she has made statement against the petitioner, on the strength of which the charge sheet has been filed for alleged commission of offences punishable under section
376 2N,
376 2N and
376 3,
yes
354D,
419 section
370.
4 2 and 6 up POCSO 363 420 and 384 IPC also. In the Ms. Sudhata Jana appearing for the petitioner submits that the petitioner is in relationship with the victim, and the parents of the victim are dead against the alliance. Therefore, the entire situation has been created and the FIR has been lost. That full stop. That perhaps she further submits that perhaps the reason initially the victim did not agree to make statement against the victim, against the petitioner. However, on the insistence of the family member, she has turned around and made statement against the petitioner. In the present petition, petitioner is seeking passing up entire criminal prosecution initiated against him. In the petition at para 5, para 6, it is specifically award age under para 6, page 5. Page 5. On instruction, Mr. Sudhata Jana submits that the petitioner is ready and willing to marry the girl, but for the ongoing investigation and threat of arrest, he is not able to take steps. At present, the victim is a major. The petitioner is, what is the age of the petitioner? Petitioner is
27 years
old. Regarding head to the statement made by the learned counsel for the petitioner and the averment made in the petition and para 6 says
6 and 9, para 6 and 9,
para 6 and 9 today 6 and 9 is reproducible. I am of the considered view that the petitioner be protected for about a month, so that the statement so that to see the bona fide of the petitioner, bona fide of the petitioner, issue notice notice to in opposite party number 2 and 3, for opposite party number 1, Mr. Vishwal expected regarding head to the aforementioned. The petition, no course of action shall be taken against the petitioner. Release the matter on 25th of April.
Oh, bless.
Okay.
Urgent
Let us see by
Yes,
25th what
it is
happens.
ready. That's what for which I have filed. Otherwise, I would not.
And I wish that you bring both of them here.
Yes, both of them should be here. My lord, urgent copy of your lordship.
Urgent.
Oh, bless.
These are very
Sensitive.
very sensitive, very difficult issue to balance. If you go by strict law,
It will not.
then you spoil the life of both.
Both.
That's the problem.
Yes.
Yes.
45.
Actually, this is a compromise matter. Both the parties will be appearing today. So kindly will this matter be taken up at 2 p.m.
So, right?
46.
Conviction under 13 of PC Act, along with 409 for 2 years. 2 years.
Regular appeal. I am appearing through virtual, my lord.
Okay.
My appearance may be noted, my lord.
Okay. Yes. 47.
Fine is also there.
Call for PCR at all. No? Yes.
Bail and fine.
Bail granted. Realization of fine of the state. Yes. 47.
My lord, challenging the order dated 28/9/2024, rejecting the discharge application of the petitioner. My lord, this matter relates to the distribution of coal to MSMEs. My lords, there is an order of my lord. This matter relates to distribution of coal to MSMEs pursuant to that coal distribution policy. The allegation is that DIC officials have identified fake MSMEs, and pursuant to that, the coal has been distributed. Two officials, the general manager as well as the assistant general manager, both have been, the proceeding against them have been quashed. This person, the present petitioner, is the industrial promotion officer. I have annexed the orders here at Annex 5 series.
Which order?
The quashing orders.
Page?
Page 118 to 133.
Lordship, if Lordship permits, my lord. The similar matter is also there in Lordship Board serial number 47. Yesterday matter, Lordship directed me to verify the factum similarity, whether the petition
When
starts
that matter is listed now?
today or at serial number 47.
No, serial number 47 is another matter, 650. That was 511. Yesterday's matter is 511.
No. The same issue, my lords. Distribution of subsidized coals, my lord, in open markets.
I'll issue notice, let us see, because whether they are covered by this judgment of this court.
I think you have given the copies.
Sitikant strategy.
It's annexed.
Annexed 5.
That receipt also the copy they
Give a copy, extra copy. Give issue notice. Mr. Sangram Das accept notice. Then counsel for the petition undertake to supply a copy of the entire petition. Please subscribe. Yes. Yes.
The serial number is? Serial number is?
Yes, 48.
PCR
48.
Serial number of what, sir?
No, this is 47, my lord?
Yes, 40.
No. Sorry. My lord, this is that case, Lordship, last night. This is not covered, my lord.
I just issue notice.
No, my lord. Lordship, can't turn to my lords. I'm sorry, my lords.
47.
This is the 47 matter.
Prasanto Kumar Parija.
Yes, my lord. This gentleman, my lord, the entire thrust of his argument that his case falls within the ambit of that particular order Lordship passed, that is at Annexure 5 series, my lord.
Yes.
5 series, page 118, my lords. Lordship, turn to page 118, my lord. That's a 5 series, my lord. In which, my lord, here, 2 judgments of this court was, my lords, appended, my lords. And in the first case, my lord, at page 118, my lords, that Lordship judgment, I was considered the counsel for the vigilance, my lords. And Lordship turned to page 120, my lords. I think Lordship got it at page 120, my lord. Lordship turned the bottom portion. This is a government order. The Sitikanta Sarangi.
Yes.
When the petitioner want to sell in that particular case of Sitikanta Sarangi, the second name is Sarendra Kumar Naik, my lords. And Lordship turn to next page, 121, my lords. Next page, my lord. This according sanction was declined by the governments. That's a catch, my lords.
In that case, sanction against these 2 persons, Sitikanta and Shailendra Narayan, was declined.
On the other hand, Lordship can turn to the facts in this case. Lordship turn.
In your case, what happened?
Yes. Lordship turn to page 21. 20 is the input audits, my lords.
20.
Page 20.
Yes. Yes.
That particular plea was not taken before the Lord in trial at the time of consideration of discharge application. And my lords,
yes.
Then, my lord, at page 25, 26, my lords, here the sanction has been granted, my lords.
I've also mentioned in the argument that sanction has been.
No, sanction has been granted in this case.
This case, it has been granted.
And then how this case, you stand on the line of the other 2 judgment in relying, lords. Sanction has been granted. I'm unable to place that particular words. I didn't find the notation. Lord, here the main grounds, the main materials which connect him with the alleged offense, my lords. He was a officer, my lord. He was back asked by general manager that go and kindly verify there's two particular units, my lord, which are actually fake units, my lords, not registered and all these things, my lords. But he gave an opinion in favor of that. He submitted a report mentioning that both the units are working. The opposite, these two units are non-existent, my lords. And the subsidized coal was sold out in the open markets, my lords. That's a finding, my lord, materials which reasonable connects him, my lords, in the alleged offense, but cannot stand at par with the two cases, my lord, where the lordship has passed orders because non-sanctional.
Let's make page 93 of that.
You simply tell me whether sanction is granted or
Yeah, yes, my lord. I'll just find out.
granted.
Yes.
Then these two, Annexure 5 goes, not to the benefit of you.
My lords, I'll satisfy your lordship.
Huh?
I'll satisfy your lordship. Why?
What satisfy that cases I have reproduced the instruction
orders
given by the government saying that no sanction is taken. So therefore I quashed it. As simple as that.
My lords, though both the officers are senior officers of
Maybe senior officer, but sanction is not given. In your case, application of mind is there, sanction is granted. So on merit I can't do it. That's the distinction.
And that apart,
That's the only distinction.
there are also materials on records which reasonable connects him, my lord, the alleged offense, my lord. He was authorized, my lord, by the general manager. Go and look at these two fictitious or the non-existent units, my lord. What is
merit you? What is
he gave the opinion that they are working.
Huh?
page 93 of the chart.
93?
Yes, ma'am.
Okay.
Chart.
Yes.
Last paragraph.
Yes.
Again, Sri Robinaran Behra and Sri Prasant Kumar Manti, proprietors of both the units of JB Enterprises and Prasant Kumar Manti, respectively on 26/5, applied for allotment of the coal. This is the year which is considered in under this set.
Yes.
Now, how?
And
Carry on.
requested to recommend the case to OSIC Limited. Sri Banambar Das, the industrial supervisor, DIC Jagatpur, put both the application before Sri Sailendra Narayan Naik, assistant manager. On the same day, Sri Naik noted in the note sheet for verification of records prior to recommendation, forwarded the file to Stitikanta Sarangi, the then GIM DIC Jagatpur. Sri Sarangi ordered for verification of past performance of the units by the industrial supervisor. The industrial supervisor here is Banambar Das.
On your report, everything has been done.
But
you are the person who has given the
No,
report.
I am not Banambar Das.
See,
the reliance on the reliance.
page 93, second paragraph.
My lord, these are based on the affidavit they have given and
93,
and the
7,
documents produced.
charge sheet, second paragraph, page 93.
Yes,
Read
my
it.
lord. Sri Robinaran-
Prasanna Kumar Parija, that is you,
Yes.
IPO, Rasulpur,
Rasulpur
block submitted a inspection report for PMT, registration of the
Pursuant to
unit,
that, the court was
recommending
not-
for the permanent registration, showing the unit as a smokeless coke unit and with installation capacity of so and so per annum.
registration.
On the basis of the recommendation of Parija, IPO, the unit has been issued so and so by Sitikanta Sodangi, GM and so. And same Sitikanta Sodangi, sanction is not granted, therefore I passed.
He's the one who
Rightly sanction is not granted because on your recommendation he has acted upon.
not my recommendation, my lord. My lord, the recommendation has
submitted the
come from
report.
industrial supervisor Banambar Das. The document.
What will I do with this finding in the charge sheet?
My lord, this was for the year 2008 when the documents were produced before me.
I think you thought that by showing Annexure 5 you may succeed.
The reliance is misplaced.
1 minute may succeed, so therefore he is not prepared properly. The young man, let him prepared. I'm simply adjourning it. Section, Annexure 5, don't rely. Annexure 5 is
Misplaced.
not to be, you are any help to you. On merit, if you can satisfy, I would have dismissed it, but because I see that you have not.
No problem. No.
Let him
Let him have a chance.
He should,
But no notice,
he should have a chance. Prepare on merit. Don't show Annexure 5.
No,
Okay?
no notice, my lord. Only
No, I'm not issuing. I'm not issuing. Simply admit. Okay. Prepare on merits if you can. Huh?
Yes, ma'am.
Let him prepare, Mr. Das.
Oh, no problem.
Young man.
No, yes. You should
Okay.
come. You should come.
Yes.
Mate is your son. The way Mr. Das is arguing.
Yes.
My lord, here, my lord, I have challenged the order passed by the learned special judge rejecting my application filed under 239. The court, my lord. My lord was pleased to issue notice, and the interim order was also passed. Here, my lord, basing upon the complaint.
Mr. Das, are you ready?
I'm
Can
ready,
we
my lords.
proceed?
I'm a bit scared of crossing shoulder with my learned friend, my lords, because in fact, this is a case, my lords. He is correct, my lord, in all the averments, my lords. One of the accused persons, my lord.
I gave they means there must be something. Otherwise,
One person, my lords, the sanction was granted in favor of one junior engineer, and he approached the Honorable Court. The sanction order was quashed by the Honorable Courts, my lord. And my lords, in fact,
with regards to other two accused persons, no sanction was given by the authority.
The two other persons are not government declines, my lord. But so far the matters involved in this case, my lord, lordship may not pass any orders. But look at page 42, my lord. Startling facts coming out, my lords. 42, my lords. The same person, the petitioner, my lords.
One point by Lord may answer before going to the charge sheet. Before going to the charge sheet, it's a complaint case. In the vigilance case, where a complainant has drawn the attention of the court by filing a complaint, which was sent under 156(3). Whether a complaint which is being sent to the court to the police station for investigation under 156(3), sanction is necessary or not? That is a preliminary question. 2014 Supreme Court, if I have correctly remembered, 2014 SCC Criminal Volume 1, there is a decision, my lord, whether sanction is necessary or not. But here is a case, my learned friend says he will not argue, and he has argued. Let me clarify the position. No.
You are trying
putting the ball in your court. Let me submit, my lord. It's a case where the petitioner before my lord was
Mr. Das always
I know,
pleasantly oppose things.
But I know his things.
Yes. Yes.
So, my lord, here the petitioner was elected as a chairman of Panchayat Samiti in the year 2002. It is alleged a complaint petition was filed by the complainant making allegations that the work has been allotted to the.
Yes, Mr. Das, will you proceed, or I'll put it some other day?
Some other day.
Some other day. Why to waste time? Least it after 2 weeks, interim arrangement to continue.
But still, then, my lord, I'll be, I'm not satisfied. I'm not, Adjournment. Your lordship, turn to page 42, my lord.
Unnecessary kind of
Okay, let him see 42.
Page 42, my lord. This gentleman, his name, the petition of lordship is Lakshmanath Tripathi. What he did, my lords. My lordship can page 42, my lord. I'll just few lines only.
Yes.
But I lordship leave the first 2 lines, my lord. The third line, Lakshmanath Tripathi, chairman of Nayagarh block, for taking of renovation of the work of Parvati Sagar Tag of so-and-so village, and the fake name of the Lakshmanath Sadaki. He changed his title, my lords, and signed all the agreements and all this thing. He did a vice and misappropriated the entire amount. Lords, you can see that.
Not misappropriated. Again, for the sake of submission, you are committing something.
By manipulation, Lords, you can
not by manipulation. What has actually happened?
That is your case. Let me place that. My manipulating. Sunita say, manipulating the copy of the.
This is the observation of this honorable court, and for which sanction order was cancelled. Perhaps Justice Honorable Justice I. Mahanti has clearly hold that when work has been done, there is no misappropriation, there is no allegation that everything is fake. While other friend says
next page.
It's not that.
Anyway, next page also.
Not anyway.
But there are two division bench judgment also.
Next page.
Division bench ballot is
pertaining to junior engineer.
Oh no.
The Lakshmanath Tripathi.
Lakshmanath Tripathi is the present petitioner. He was suspended. He has challenged before this honorable court, and his deed was allowed.
No, not about this particular, my lord. He was removed from that chairmanship. My lord.
On
Challenging that.
on the same allegation.
This is one of the. No,
Same
my lord.
allegation it was filed.
He was, it was allowed.
My lordship, on to page 43, my lord. That speaks volumes. My lord.
Charge sheet.
Page
Okay, we'll
43.
see.
Anyway,
With any case, we'll see. Allegations are there.
serious allegations.
Technically, he's taking.
Showing high-handedness, my lord. And that too, my lord, that the government handwriting experts. What is that?
The offense might have been committed, but he's taking technical plea.
But
and you can't.
Technical plea under 239, my lord. This particular input order emanates from my application filed under 239. The materials produced
We'll
access the true.
We'll examine. Yes.
Comment
49. 49.
The interim order is there.
No, interim arrangement. 49.
May I please, your lordship?
Yes, tell me the dates.
Accused statement NI Act, my lord. At the stage of accused statement, my lord.
My lords, I have filed.
12/4/24.
My lords, I have filed an petition recalling the seeking for recall of the witness for cross-examination and verification of my signature by handwritten expert. I have not given any signature to that check. My lords, that was rejected by JMFC Rural Baleshwar. And non-bailable warrant was issued against me.
You are against non-bailable warrant, no?
Yes,
Yes, sir.
NVW issue for year current. No court. Yes. Yes. 50.
May I please? The petitioner challenging the order issuing NW. The petition was earlier on bail by the Supreme Court, annexed to 1 minute.
Tell the dates.
25/3/2017, my lord, bail. And WW, my lord, 29/11/2024.
500. Yes.
Mhm.
Yes. 51.
51 bail, my lord, 11/4/2022.
Yes.
And NBW 39/2024.
Tell the dates.
That is 15/5/2018. He was on bail and WW issued on 4/2/2025.
500. Yes.
52.
Well, petitioner released on bail on 11/4/2022. NBW issued on 3/9/2024.
500.
Okay.
Yes.
53.
May I please also? On the prayer of IO, NBW was issued against the presentation on 28/8/2020.
Charge sheet filed.
Charge sheet, my lord, filed under section.
Process issue 82/83, my lord.
Charge sheet was filed showing the petition was misconduct and the prayer of the IO NBW issued on 28/8/2020. 1000. Yes.
Local bar, my lord.
Local bar. Yes.
54.
BW issued on 12/2020.
Available warrant against.
12/2020.
Why are you coming against bailable warrant?
Magistrate goes on the orally.
Bailable warrant issued against. 12/8 ठीक है
12/8/2020.
Don't put cost, no cost. 55.
55.
Here 41A issued, thereafter NBW, my lord, on appearance 10/2/25.
Date.
My lords,
Here 41 notice was granted.
That is 56, my lord.
56.
56.
My lords, in
What happened to 55?
NBW was issued on 27/2024.
Copy the
Mr. Ponda, again you are confusing 55 to 56.
55 copy the Nandi. Oh, 56. Copy the
NBW was issued on 27/2024. Lordship, on that day, on the date of.
Tell me the bail date.
Yes, sir.
You are on bail.
Yes, your lordship.
Date, tell me the date. Now you come.
That was in the year 2014.
Tell me the date if you have.
Lordship, I don't have that date.
On bail. Yes. 56.
May it please, your lordship. 56, the IO granted 41A notice to all the petitioners, my lord. Thereafter, on the court issued notice, they can't appear. For that reason, my lord, on 10th February 2025, NBW order.
Okay. 500. 500. 57.
57, Adjournment matter, my lord. Earlier, my lord, 41
41.
complied, and due to the non-appearance on 20/10/2022 and 27/6/2023, warrant was issued.
ଗୋଟେ ଡେଟ୍ କହିବ ନା ଦିଟା ଯାକ
ତିନି ଜଣ ପିଟିସନର ଅଛନ୍ତି ତ ତିନି ଜଣ
500 each. Yes. 58.
58.
19/6/12, when in bail, or on 4/2/25, I was not taking any steps, and NBW was issued, my lord.
You got the dates? Okay. 500. Yes. 59.
59.
Same, 59, 60.
Same.
59, 60, both same.
59, 60. Same. Okay.
Original certificate.
61.
61.
Pass over. Yes.
62.
Notice for limitation had gone, but open number one is returned. Previously one notice was returned also.
First step you take. Answer to.
I had insufficient address.
Address is not known. Requisites filed, fresh requisites.
No, my lord.
Persons to the
My
order
lord,
dated.
twice it has returned, my lord.
Pursuant to the order dated 6/9/2024, the requisites has not been filed by the petitioner. Let him do so within a.
ସେଇଟା ପାଇଲେ ତ ସାର୍ 6 ନମ୍ବର ଅର୍ଡର ଅନୁସାରେ ପାଇଲେ ତ ପୁଣି ଫେରିକି ଆସିଛି।
Where is that service?
ଦିଥର ପାଇଲେଣି।
Insufficient address, file fresh address then.
ଆମେ ସାର୍ ହଉଛୁ payment ଆମେ
Pursuant to the order dated 6/9/2024, service could not be completed. The postal report.
it is combination of two, my lord.
Address is insufficient. Let the petitioner file fresh address for the opposite party number 1 and file requisites for the property of the service.
My lord, ଆମେ ହଉଛୁ ବେନିଫିସିଆରୀ ପାଇଁ ତା ଆଡ୍ରେସ ଆମେ ସଫିସିଏଣ୍ଟ ଆଡ୍ରେସ କୋ ଇନ୍ସୁରାନ୍ସ ବାଲାଙ୍କର କହିଲ ଦିଥର ନୋଟିସ ପଡିଲାଣି।
You have to give the address where per mile get. Service has to be there.
ଦିଥର ତ ଦେଇସାରିଲାଣି ପଡିଲାଣି।
What can I do?
Delay ଟା
Then you know what to do. You file substitute service, publication or something. I can't serve it. You have to serve it. You have to give the take the necessary steps. It is at liberty to take necessary steps by way of last chance. Yes.
May I plead your lordship? My lord, we have challenged the order dated 27/9/2022 passed by District Judge Puri in FAO number 12 of 2022, which confirmed the order of Civil Judge Junior Division Puri dated 28/12/2021 in IA number 39 of
What's the
2021.
service position?
My lord,
Service.
a notice has not been issued to the opposite party.
Substitute legal as
This has been allowed and consolidated cost title has been filed.
You filed?
Yes, ma'am.
Okay, issue notice. Issue notice to the opposite parties. Requisites to be filed within 2 days. Yes.
64.
4.
Or the CRL MC number 1367 of 2023 was dismissed for non-prosecution on 11th of May 2023. On 8th June
H20.
It was
This is allowed, non-prosecution.
What was that CRLMC?
CRLMC, the allegation was that the petitioners, my lords, they had taken away the acacia plants from the land of the informant. But my lords, the CRLMC petition, my lords, the land, the schedule of the land, the ROR is recorded in the name of another person. So on that ground, my lord, the CRLMC was filed.
ROR may be in somebody's name.
But my lord, and the fact that, my lord, there was a pre-existing enmity and on that it was and my lord,
seeking quashing.
Yes, my lord. So on that ground, the quashing and it was dismissed on 11th of May.
That's right, but 34 petitioners.
Yes.
Yes.
There is nothing in the CRLMC. CRLMC is bound to be dismissed. if there is something, you have got a stay there in CRMC.
Well, it was dismissed for non-prosecution.
I know earlier, was there any order?
At the stage of admission.
No, well, there was no order. There was no order.
Restore, for the reasons stated in the application, the order dated 11/5/2023 is recalled. CRLMC number
1367
of 2023 is restored to its original file. Lease the CRMC next week. The CRLMC will be dismissed. Don't worry. Yes. There is nothing in fact.
379 AJ.
Pardon to mention, item 60, there is an IA for stay.
If you notice on the stay application. Yes.
65.
$65. The report has come. Report is done. Last shot was 29/4/2024. Further 3 months' time is sought. The matter is listed today pursuant to the letter dated 24/2/2025 submitted by Special Judge, Special Court, Cuttack, wherein the learned Special Judge, Special Cuttack has sought 3 more months extension for concluding the trial. In the letter, the learned trial court has given reasons for not able to conclude the trial as per the stipulation. It is stated that the accused has been taking adjournment. It is stated that after the conclusion of the prosecution evidence, the accused has been taking time for recording of his statement under 313 CRPC. Due to frequent adjournment sought by the accused, the trial could not be concluded. For the reasons stated in the application, 3 more months, 3 months more time is granted to the trial court to conclude the trial, and it is open for the trial court to take necessary measures for not allowing pass necessary orders, but not allowing either the prosecution or the defense for adjournment in this case. So there is the petition. Simply, it cannot be shown. Yes, dispose of quality. Yes, next.
66.
May it please, Your Lordship. Item number 66, my lord. It is a case of gang rape, Your Lordship. The police filed charge sheet under section 376D, 376(2)(n), 354A, 354C, 506 and 34 of IPC, read with 6 and 12 of the POCSO, and also 67B of the IT Act, Your Lordship. 2 juvenile are there in this matter, my lord. 1 juvenile, the learned court below, without issuing notice to the victim or to the guardian of the victim, passed the order for release of bail, my lord. For that matter, the victim is the petitioner in this matter, challenging the order of the appellate court, and Your Lordship, that is prayer is at page number 9. Previous order there, this honorable court directed to make the guardian of the accused as a party. I have filed the consolidated cause title, IA and also consolidated prayer person. The IA is 2599 of 2023, my lord. That needs to be enough. 2599 of 2023. The IA
What
number.
is this? This IA is for?
IA is for, I have already added the guardian of the accused as a party. So, Your Lordship, I'm praying amendment of the cause title and prayer person, Your Lordship. And also, Your Lordship.
For the IA number 2599 of 2023. For the reasons stated in the application, the same is allowed. The petitioner is directed to file the amended.
Already filed, Your Lordship.
Already amendment party filed by the petitioner is taken on record. Yes. Next.
Your Lordship, a notice may kindly be issued to the.
Where is the impure order? Show me. You say that the bail is granted without issuing notice.
Your Lordship, I have appended the certified copy in a different memo. Certified copy of all orders it passed in criminal appeal number 20 of 2020 may kindly peruse, Your Lordship. I have appended all the orders it.
Which order you are talking about? Bail.
Bail, my lord, that is 2020, the petitioner, the accused filed bail application before appellate court, and the appellate court allowed on 4th February 2021.
Where is that order? That's what I wanted to know.
I have filed, Your Lordship. That is through memo I have filed.
Then I'll issue simply notice, huh? Issue notice.
Notice to all the opposite parties.
Notice to all the opposite party. Mr. Maharana accept notice for the state. See what he says that see these are POXO case and all. Without issuing notice, bail is granted. So therefore he seeks cancellation of the bail. Yes.
Grateful.
In this case, the petitioner has prayed for motivation order dated 12/2/2025. On that date, I filed a memo for withdrawal of the CRLM's application. The Lordship was pleased to allow it. They are granting liberty to file with better particulars. That what liberty is not there. The Lordship can glance.
Better?
With better particulars. Liberty is not there.
On 12/2/2025, the petitioner has sought for withdrawal of the CRLMC number 3581 2023 with the liberty to file a better petition with better particular and all necessary documents. However, in the order, the liberty part is not reflecting, hence he filed this application. Accordingly, the liberty is granted to the petitioner to file a better petition with better particulars and necessary documents.
Obligement.
Yes.
68.
This is not sufficient.
Mm-hmm.
This is not sufficient, my motion. On 498,
On 6/2/2025, the notice was directed to be served through the IAC Begunia police station. The instruction from IAC Begunia police station has not yet been received by Letter Counsel for the state, and she seeks an adjournment. Lease the matter after 2 weeks. Yes.
Obliged, my lord.
69.
Please, Your Lordship. Previously, Your Lordship heard this matter, my lord. Last order, Your Lordship may kindly peruse. Learned Counsel for the petitioner submitted that when the prosecution evidence was recorded, PW 23 was examined by the prosecution, who has produced the school admission registered, which has been exhibited as Exhibit 15-1. The said document has been exhibited without any objection. Exhibit 15-1 reveals that the date of birth of the victim girl is 9/6/1998. If the date is to be recalled, then on the date of alleged offense, the victim girl was a measure. Hence, the alleged charges under the POXO Act need to be relooked thereafter. Therefore, he moved an application before this Honorable Court for alteration of the charge, which has been turned down by the impugned order dated 1/2/2024, my lord. Previously, Your Lordship issued notice to the state. Ms. Maharana accepted the notice, and OP2 also appeared, my lord.
my lordship, they filed a prepone of the prepone I because 64/25. Because my lordship, I say that there is a difference of 8 years. When the girl is submitting the statement that she is 14 years, and the school registered certificate was 24 years.
But that was taken, that was exhibited as Exhibit 15 of 1.
It must have, it was already reported from the school. He has also reported that, in the school register, it was written, for 9th June 1998, date of
Then?
birth. That I have to see now.
Then what do you want as service? Serve through the IO.
My lord, already served. The counsel for the victim is already appeared. He is not appeared today. One Mr. Pujari is appeared for the victim.
But 164 statement is all right. But some document is filed where the date of birth is 98. That was exhibited without objection. Some document has not come. Has come. Now the headmaster also says the 98.
Since January 2021.
Pursuant to the order dated 29/11/2024, notice has already been served on opposite party number 2. However, Wakalatnama filed?
Yes, my lord, Wakalatnama filed on behalf of the victim mother.
So, Mr.
A.
Arvind A. Pujari has filed the Wakalatnama, but none appears on behalf of him today. Mrs. Maharana seeks an adjournment to get instruction in the matter. Lease the matter on so and so. In the meantime, proceeding before the court so and so is stayed. Yes.
My lord, I am praying short adjournment kindly be given, your lordship, because since January 2021.
I am staying the proceeding, so therefore I'll give it. Stay the proceeding.
Grateful.
To the proceeding. See, the difference is 10 years. How will you ignore a exhibit which has come on record without objection? The completely ambiguous situation. Okay, we'll see.
Grateful.
Yeah, good for it. Yes. The number did stay good. Yes.
17.
70 lordships. I'm stuck in the process of law lordships. This is matter is lordship. The petitioner was driving his Honda City car, and who was sitting in front of with him. He both have met with an accident, and one died, and he suffered injury. Thereafter, after became well.
Who is appearing for 2 and 3?
2, I had sent a notice, but
Just see the service position. Just check it. Service position. You didn't file in time. Notice was issued issued to the opposite party 2 and 3 by the order dated 3/2/2025. The notice could not be served because the requisites were filed late. Let the requisite be utilized for the purpose of service of opposite party number 2 and 3. Leave the matter for 2 weeks. Yes.
Any specific date?
2 weeks. Yes. 71.
71.
Interim order to stay of the proceedings. Stay of the proceedings to continue.
I have not said it earlier.
No, earlier order.
If it is there, it will continue.
That's
First of all, you have not filed the process. Now you are asking for stay. What is this?
no,
I wanted to give indulgence.
No, earlier there was a stay.
If it is there, it will continue. Don't worry.
Let's.
The chief continue. Yes.
71.
May please.
In the last occasion, your lordship directed the state to obtain instructions.
Yes. Have you got?
They filed a petition, they filed this evidence for the release of the vehicle. And my lordship, what happened, Sriram Finance is saying that I think the vehicle should be returned to me because of that person who was the owner of the vehicle has not paid the loan. So here, my lordship, as per the, I have reviewed the SEBI, and that is the
The vehicle stands in whose name?
name of the, not, Sri Ram Bhatt, in the name of the achievement.
OP number 2.
And my lordship, one thing is that the registration number, my lordship, they are saying WB 11D.
But this is an hypothecated vehicle.
Mile. In the seizure list, my lord, the vehicle number is WB 14D 5961. And in the FR it is 11D.
No, you have got the finance from Sriram Transport Finance Company Limited.
Yes.
And
the
the
Sriram
vehicle
Finance.
is hypothecated.
Right.
Have you paid the entire amount?
No. I am Shriram Finance, my lord.
You are Sriram.
OP number.
Who is the accused?
Accused is my lord OP number 2.
Let's see. Notice was issued. Let's see the service. Not sufficient. Notice on opposite party number 2 is not sufficient. Petition to take fresh steps for serving opposite party number 2. Yes. 72. No? Next.
72.
May it please, your lordship. Item number 72, my lord. Here the complainant, my lord.
IIC culture to serve opposite party number 5 and 6.
Opposite party number 6 is appearing, my lord. I am the opposite party number 6. And the opposite party number 5 is the husband of the opposite party number 6. My lord, he is in jail custody. He knows, but the address has been wrongly given. He is in custody, my lord, since long, my lord, in connection with the PS case, my lord, calculate PS case number, my lord. But his home address has been given. That is why notice has not been served.
5 and 6. Service 6, somebody is there.
My lord, I am.
You are appealing. Okay. Mr. Naik has entered appearance for opposite party number 6. However, insofar as service on opposite party number 5 is concerned, the IIC Culture Police Station has not furnished any report. Let the IIC furnish a report by the next date of hearing. Leave the matter after.
My lord, he is in custody, my lord. So that is why, my lord, the address has been given, the home address, my lord.
Mr. Naik further submits that as per his instruction, opposite party number 5 is in custody in some other.
No, in this case, my lord. And he knows, my lord, he is in custody.
Hence, the petitioner is directed to take appropriate step to serve the opposite party number 5. Do you know the jail?
My lord, of Hon'Ble jail, my lord. In connection with this culture PS case number, my lord.
Laws in Hon'Ble jail.
641 of 2000.
Pardon, your lordship. Your lordship, if the IAC, if the IIC is already directed to serve the notice, your lordship, the IIC concern IO of that case.
IIC will do.
You know the address.
Now you came to know that it is in the Hon'Ble police.
Yes, you have misled.
Yes.
I have not misled. You have filed a bail application.
Because in pursuant to your case is in custody, and you know about
you should have informed the court that he is in custody.
The learned
wrong notice has been given
I have
that
misled
he is
this
in
on
the
the
house.
court. Whether their bail application address is same or not. Yes or
Bail
no.
application address, that is the
Anyway,
you
now
told me where is the address.
Anyway, now you came to know about the address of opposite party number 5. Do it.
Yes, your
He is
lordship.
in Hon'Ble police station.
He is in connection with his case, my lord.
Let him, sir. Let him, sir. Okay.
Pardon, my lord. Item 61, I was little late.
Item 61, I am for the OP. Because of my
61, I don't know what happened.
Passover.
Passover. Okay. Passover.
One both pair. And pain has to take another substitution application because petition number 1 expired 2021. If it is taken into account, that is abated. If you will not take it, then
I take inspection. Let it be taken up 2 weeks after.
61.
And entry protection is also
he came to. He got the information that petition number 1
expired.
1 has already expired.
In the year 2021.
Next step. Yes.
Date be fixed because of stay is continuing since March.
He'll fix the date.
Yes,
Yes.
Sorry. I have already informed Mr. Mishra, I am for the opposite party. Due to petition of 2016, I appear
What do you want?
2 weeks after I inform.
You are for opposite party?
Yes.
Number?
29.
Opposite party number or the opposite party?
1A.
1A. On behalf of opposite party number 1A, 79, huh? An adjournment is sought. Release the matter. Yes.
2 weeks after. Application is rejected Maloney draft case notes.
Non-appeals for the petition. In the second call. In the interest of justice, adjourned June. There is no say, nothing. Simply June. Yes.
Item 10. Challenging the order dated 10/9/2024, madam. In rejecting the application filed under section 311.
Yes.
Case under section 376 now. And
376.
Madam.
Who is PW1? PW4?
PW4 is the victim, madam. And I have given the questionnaire. I have to file only ask to 5 to 6 questions. I have given
Let us see her test, deposition.
Deposition.
Why have you not asked these questions?
Some formal question, my lord. That was
where are the questions?
my lord. Page Annex 4, page 18, my lord.
Do you know the name of the accused?
My lord.
Have you seen him at
Any
the
point of time before
when
this
he put down
report?
report and primary examination? The police never told you the accused. Whatever you. This is 376. What kind of question here? This.
My lord, what is the relationship I am trying to?
I think you own our head
No.
after deposition. See the questions.
My lord.
What is the question? Do you know the name of the accused? 376.
One chance. One chance may be given.
Direct question you are asking because she will say, no, I don't know, you will get acquitted.
No, no, that.
See, this is the, no, you have own over that witness.
No, no.
See the questions.
My lord, do
Can it be permitted?
that may be deleted, my lord.
No, why? So that rightly the
if your lordship, my lord, that is.
See all the questions. See all the questions. One after another. Have you seen him?
Have you seen him at any point before the honorable court? এটা কিছু compromise no. First,
Police never shown you the accused.
The police.
All these questions are framed aiming at a particular answer so that you will be out. Therefore, trial court is rightly rejected.
The trial court has routinely rejected.
whatever questions are.
Only stated that you have already examined, so only immediately I have filed.
Yes, see, question number F, just read it.
That you are seeing him today, against whom you have not made any report, as he was never kept any physical relation.
It's kind of
Yes or no?
like 376.
One day, I will give the cost, One day,
No, but I have no problem. I generally allow one. But the kind of question you are framing.
Then I have liberty.
This is your
Liberty may be granted, I will file a better application.
You do whatever, but these questions, I'll have to record that. The questions.
Liberty may be granted, I will file a better application. That will be considered. 311 the cost stage
Page 9.
Page 9. Let us see. Yes.
311 how could again?
Rejected.
Huh.
Every the case a person found that the victim ready, Peter 4 was examined, cross-examined and discharged on 21/8/24. Peter 4 was extensively cross-examined by the lawyer.
This is the routine. See, extensively, just see the cross-examination.
Not extensively.
3 questions put to.
My lord. Only 3 questions.
Question number 5, 6, 7. What is extensive? No. You have to be fair. Just see, come to page 17. Come to page 17. Only 3 questions were asked.
17.
That is question number 5, 6, and 7. So how can the trial court say that extensively cross-examined? This is not correct. And he is facing a charge under 376, serious charges. He has a right to cross-examine, there is no problem. Because he is not put appropriate questions. But the kind of question he has framed, this is very dangerous.
Your lordship will delete the question number 1 and rest of
No. All the questions has to be deleted.
Then your lordship
Petitioner is agreed by the order dated
10/9/2000.
Date
10/9/2024.
Okay, 10/9/2024, whereby the application under section 311 CRPC for recalling PW4, the prosecutrix in this present case has been turned down. The petitioner, the prosecutrix was prosecutrix deposed before the court on 21st August 2024, and she was subjected to cross-examination by the defense. Thereafter, the petitioner moved an application under section 311 CRPC on 24/8/2024, and enumerating therein the 6 questions. 6 questions, which according to the defense is necessary for the purpose of necessary to be put to the prosecutrix. The trial court rejected the application. I have perused the rejected the application, hence the present petition. I have perused the application moved by the petitioner under section 311 CRPC. The question is, the proposed question is, proposed question is to be put to the witness sought to be recalled. Cannot be allowed as the questions are either leading questions and leading questions. Therefore, therefore this court disapproved all the questions proposed by the petitioner to put to the prosecutrix. In that view of the matter, the present petition fails. At this stage, Mr. Tripathi submits that liberty may be granted to him to move a fresh application under section 211, rephrasing the questionnaires. Liberty granted to the petitioner to move appropriate application to the trial court and rephrasing the questionnaires. The trial court shall evaluate the relevancy of those questions and decide the application in accordance with the law. Yes.
19.
Yes. 19?
19. 19.
Yes.
Next.
Yes.
The petitioner is a mining lessee.
These were granted in 2016. In 2017, the Mineral Conservation and Development Rules came in 2017.
Yes.
There an obligation was under Rule 27(2) for deposit of the assurance money that is to be done by a bank guarantee. It was not done. They initiated a complaint case, UCC, by the IBM. Now, subsequent to that, we deposited that bank guarantee. Now, if your lordship will kindly see Rule 62, that is the provision where they get power to initiate
Have
the
you, have you,
prosecution.
have you reproduced?
Yes.
Where is that? Yes. Yes, page 4, 62.
Page 4.
Penalty. Whoever
Contravenes any of the provisions of these rules shall be punished with this and such. Thereafter, you kindly see next page, page 5, proviso. Provided that any offense punishable under these rules may either before or after institution be compounded by the person authorized under section 22 of the Act to make a complaint to the court with respect to such an offense on payment to that person for credit to the government. Now, I have made that payment by a bank guarantee, your lordship will
then
kindly
then it become compoundable.
It is compoundable. I came before this court. Court had kindly file an application. Kindly see page.
Then if you according to you, if it is compoundable, move an application under 320.
Yes, I have moved. That is pending since last
I give a direction.
Then kindly see page 19. That was already the direction. Kindly see page 19.
1919.
Yes, madam. 19.3.21. The court records that I filed for compounding of offense. And
Where is that? 19?
Page 19.
Page 19.
19.3.21.
Both the parties present files the petition for next orders and the compoundable offense. Yes. That is pending.
I came before this court. Court directed that the court will compound the offense within 2 months. And it's pending since 4 years.
Where is that? Where is that order?
Your lordship will kindly find page 36. 37 is the operating part. Disposed of direction to the SDGM Bhubaneswar dispose of said joint petition filed by both the parties for compounding the offense.
Compounding the offense as per the order it is also.
So
within a period of 2 years.
My submission is compounding of 320 is not a bar for question.
No, but particularly after the court directed, you have not done. What do you say?
That earlier in criminal case.
Why it is not done by the trial court?
It's pending.
My responsibility that was.
Let him take instruction why it is not being done.
Yes.
Whether that earlier communicated my client of the senior lordship, whether the progress duly knowledge before the exigent or not, that will
Right.
also.
The coordinate bench of this court, while dealing with the CRLMC 1028 of 2022, pass an order dated UDHR 2022, directing the SDGM Bhubaneswar to dispose of the joint petition filed by the parties for compounding of the offence as per the order dated 19/3/2021 within a period of 2 months from the date of receipt of the certificate copy of the order. Mr. Parle, next order. Mr. Parle and counsel for the petitioner submits that despite the order, despite the said order, the application moved by the petitioners for compounding has not yet been decided. Hence, he agreed and has filed the present petition. Regarding head to the aforementioned, a report we sought from on the SDGM Bhubaneswar as to why the order dated 2048 YC passed by this court in criminal MC number 1028 of 2022 has not yet been complied. Release the matter after a week. Let the report come, huh? 8th of April. I'll call for a report. Who is responsible? Why this is not complied? Yes.
32. Passing of Cognizance matter, offense number 294/506 matter, dispute among the civil in nature matter. The charge sheet submitted matter on the ground that FIR was named Tulu Singh matter, and charge sheet submitted mentioning the my name matter, but the Tulu Singh and Raja Singh not the present petitioner matter.
Sorry,
the charge sheet submitted in my name matter. as Sudhanshu Shekhar Singh alias Siddhartha Shankar Singh. But charge sheet in the affair, one Tulu Singh was named. The present Tulu Singh is or alias Raja Singh was not the present petitioner, my lord. But in the I have annexed the statement, my lord, charge sheet.
You are Sudhanshu Shekhar Singh.
Yes, my lord.
Charge sheet, very charge sheet.
I have already annexed, my lord.
Where is that?
In every statement was mentioned as Shankar alias Tulu Singh, my lord.
No, come to page second page of the charge sheet.
Yes, my lord.
It is Sudhanshu
Yes.
Shekhar Singh alias Siddhartha Shankar Singh.
Yes. But every statement that is mentioned as I have annexed all the statement that Tulu Singh alias Shankar Singh, my lord. The present Tulu
Your
Singh.
name is no Sudhanshu or Siddharth?
I am Sudhanshu Shekhar Singh. But Siddhartha, no, I am not a Siddhartha.
Alias Siddhartha.
Not alias Siddhartha or alias Tulu Singh as mentioned the affair as even statement, my lord.
Show me the statement. One
Statement, yes, ma'am. After charge sheet it was statement.
Yes.
ऊपर तो जगह ऊपर राजा सिंह शंकर alias Tulu Singh.
No, Siddharth Shekhar Singh alias Tulu Singh.
Yes, I am not Siddhartha. I am Sudhanshu Shekhar Singh. They say Siddhartha Shekhar Singh alias Sudhanshu Shekhar Singh.
Sudhanshu and Siddharth is one and same person.
No, I am not. I am Sudhanshu Shekhar Singh.
But in charge sheet says Siddharth.
Yes,
Sudhanshu alias Siddharth.
Yes, my lord. But
now Tulu. All three names are same.
No, yes, I am not Tulu or Siddharth. I am Sudhanshu Shekhar Singh.
Yes.
Every statement,
mistaken identity.
If the charge sheet is not with me, subsequently might have been learned in fight.
Petitioner is seeking quashing of the cognizance order dated 48/2016 passed by the SDGM Kyonjar in GR case number 910 of 2016. Counsel for the petitioner submits that the petitioner is falsely implicated in the present case. In the charge sheet, the entire allegation is made against Siddhartha Shankar Singh, alias Tulu Singh. However, the petitioner is neither. The petitioner is named as the petitioner is Sudhanshu Shekhar Singh. The prosecution is trying to the charge sheet has been filed showing that Sudhanshu Shekhar Singh and Siddhartha Shekhar Singh are one and the same person, which is completely incorrect. Issue notice, don't accept notice.
I also made informant as party.
Informant has been
not to
made party. Notice to opposite party number 2. Mr. Mahanti accept notice for the okay.
One IA is there.
You move application for yes.
42.
Please, my lords. The petition challenges the order dated 22/1/2025 passed by the CGM CBI Melos Bhubaneswar, wherein the petition under section 311 to cross-examine IO, that is PW21, was rejected, my lords.
Yes.
My lords, on the previous occasion, your lordship.
Where is this evidence? 21.
My lord, additional affidavit, my lords.
Yes.
Yes, I want to confront 4 paragraphs, my lords, which appears at annexure 3, the deposition of PW16, lordship, wherein certain statement made by him implicates me, and if not cross-examined by the IO, my lords, might prejudice the present petitioner, my lords. And moreover, my lords, one previously I filed one CRLMC, my lords, as because I failed to cross-examine PW 21, Malos, and the same was allowed. 5320/2023.
Yes.
And the basis of rejection, Malos, is para.
Earlier removed the same application.
Same application to cross-examine in full, Malos. This only I have to confront only 4 paragraphs of PW 16, Lordship. 10, 11, 12, and 13. Lordship may kindly glance at para number 8, Lordship.
So this was allowed earlier.
My lords.
So why have you not done?
Paragraph
7, your lordships.
To my lords, because there are 20 witnesses.
Oh, your lordships.
From PW 21, lordship.
This is not allowed. You can't
during the course of argument
getting wiser day after day and they move application.
No, my lordship may
on the intervention of this court, and this witness was summoned. And that is summoned in 2024 March.
My lords.
You didn't do. Again you moved.
We have done, my lords.
Then
we have done the cross-examination in full, my lords.
Your lordship
during the getting ready for the argument.
Your lordship, suppose you forgot to put some question. Again you move an application. Keep on moving.
Well, this is the last, my lords, because certain, my lords, paragraphs.
Intervention. How much intervention?
Fact remains that, my lords. Lordship may kindly glance at page 26, lordship.
20?
Page 26, lordship.
Yes.
That para number 10, lordship.
Yes.
Para 10 of that is the deposition of PW 16, lordship. He has been let go by the investigation authority, and thereafter he has stated this fact, so lordship. It is not a fact that I had not stated before the IO in this case that I am an advocate at Cuttack in the year such and such, and that one the present petitioner was working with me as an associate. I had never arranged any paper for the claim, my lords, and cannot say whether the aforesaid document arranged by J. Mahanti, my lords, present petitioner. The para 11 also have underlined those, my lords, those facts.
Your lordships may kindly come to paragraph 7 of the CRLMC order which is given to your lordships right now. Paragraph 7 says that in Mr. Beuria, learned counsel for the petitioner, submits that other co-accused persons are concerned got the opportunity to cross-examine PW 21, who is the IU in the case, but he could not cross-examine the said witness. Perusal of the deposition indicates that no opportunities were afforded to the petitioner. However, he did not cross-examine the witnesses. That means, your lordship, before that also opportunities were given. He did not do so. Then in this order, it was passed, your lordships, and there is an order of the court that no further opportunity will be given, your lordships, in next page. I am of the considered view that the petitioner should get a single opportunity to cross-examine on the date without fail. That he availed, your lordships.
I can't review my own order.
Well, this was passed only because previously one occasion was.
Whatever, but I said single opportunity.
Single opportunity, we have availed, man.
Then we have
this is further cross-examination, no. This is not cross-examination, further cross-examination,
no,
with regard to these 4
I can't review my own order.
Yes.
I myself have said that one single opportunity. How can I review my own order?
Well, we have done cross-examination.
I'll reject it and go to some other court. You know that. But I can't review this.
Because we have cross-examined.
That's right.
Further.
See, I record your concession. Thereafter, I say that single opportunity is granted to you to cross-examine.
We have done.
You have cross-examined. Thereafter, you become wiser. I forgot some question. Again, move an application.
During the stage of the trial is the argument, final argument.
No, your lordships, besides
you go to court in a particular matter, you get wiser in the matter. Keep on reading, then you think that yes, I have not asked this question.
This PW 16.
On that basis, you keep on entertaining application under 311, then.
This may be the last opportunity. Why? Because this PW 16.
How will I get over this order, you tell me?
It's further cross-examination, I've done that,
I can't get over. That's the problem. That's the only problem. Otherwise, I would have. Generally, I give one opportunity with a little cost. 5,000 cost also I impose on you.
We have additional affidavit to lordship.
Last 3 lines also. Last 3 lines, your lordships have indicated no further will be sought by the petitioner.
Like BO lordship, I have already have additional affidavit,
No further adjournment will be sought by the petitioner and no prayer for adjournment shall be entertained. That is also your
That I have done, lordship, I can say like BO.
Okay, you lead defense evidence.
I have led, that I've led. My trial is, now the matter is posted to final arguments, nothing more. This, if this were only this 4 paragraphs, I will be constrained only to this 4 paragraphs.
You have only thing I can say is you have done well. I can't help you. That's the only thing I can tell you. Right? Petitioner is agreed by the order dated 22/1/2025, passed by the special CJM, CBI, Bhubaneswar, whereby his application under section 311 CRPC to recall PW 21, the IO of the case has been rejected. In the earlier occasion, the petitioner had approached this court by filing CRLMC number 5321 of 2023 for the same cause. This court, while allowing the application, allowing the CRLMC on 15/3/2024, has inter alia passed the following orders, following direction. Para 7 to 9. Para 7(8). Para 7(8). Para 7. Pursuant to the aforementioned order of this court, the PW 21 was recalled and he was subjected to cross-examination by the petitioner. Subsequently, the two petitioners has moved another application under section 311, seeking recalling of the said witness for further examination on the ground that some vital questions were left out to be put to the witness. The trial court has rejected the said application by the impugn order, hence the present petition. The prayer of the petitioner cannot be entertained in this petition, because this court in the earlier occasion had made a categorical observation that the petitioner is given a singular opportunity to cross-examine the PW 21, the IO, which has been availed by the petitioner. Allowing this petition would be tantamounting to review the earlier order of this court. Therefore, I'm not inclined to entertain this petition and to say it's dismissed. However, dismissal of the present petition shall not preclude the petitioner to lead the defense evidence, if any, defense evidence, if any, in that regard. Okay.
Yes.
45.
May I please? The compromising matter, my lord. Offense number 32, 296, 324A, 305A, 351(3), 351(3), 3, 5, and
yes, what are the allegations?
25 are in fact, my lord. But there are two crusher mills, my lord. The petitioner having one crusher mill, petitioners, and the informant having another crusher mill. There are a dispute between them. On the date of occurrence, it is alleged that the petitioners entered into their office room and damaged the chair and table, and while taking away the key of the office room, by the time the opposite party opposed, for which petitioner, one of the petitioners showing reversal stated that you give body. That is the allegation, my lord. No injury, nothing, my lord. And the matter has been compromised. There are keeping good relationship between them. All of them come, my lord.
I am happy for the informant, my lord.
Arms act also there.
Arms act, my lord, kisi use नहीं. I'll showing. That is compoundable. If it is not compoundable, the court can compound, my lord. If injury is there, my lord, gunshot injury, and then, my lord,
if you have only filed the FIR,
my lord, FIR, my lord,
where are you getting all these things? Injury is not there and all.
FIR is still, my lord.
But investigation has already completed.
My lord, all of them bail. 4 of the accused person anticipated. What about? And 1 person, my lord, is bail. All of the religion bail, my lord. By this court. Investigation going on.
I have no instance whether the charge sheet has been.
No, charge sheet not filed.
Call for CD will see. Call for CD. Let them call for CD.
There were all of them.
See, the allegations are there. Let us see. There is a revolver used. I don't know whether it is fired or not.
No, exact. They have mentioned the FIR, my lord.
But on the basis of FIR, how can I do?
I'm read out, my lord. One line, my lord. If you don't
understand it,
my lord. What? The टेबुल चेयर आदि बाड़ाबाड़ी भांगा सहित कंप्यूटर एलईडी टीवी बाड़ाबाड़ी भांगीदे ऑफिस चाबी गुड़ कांथार झुलुता बेले से सोहेल खां नहीं समय मोर कर्मचारी नहीं हाथ में धरती बंधुक देखे धमक दे कहले तुम बाबू कह दादा बाड़ी देदेव नत आसिले तुमको जीवन मारदेव दैट इज द एलिगेशन माय लॉर्ड if there would have been any allegation my lord assault my lord assault no assault part my lord
let us find out
and both of them present my lord
they present that is not the important thing they are accused they will have to come
my lord
they have come therefore I'll decide that is not my issue is let us understand what are the material came against you on the basis of the allegation. At least with
FIR
the ex parte, can it be done like
No,
that
no,
without giving an opportunity to the state? Merely because the accused person have come.
For that, you have file affidavit, my lord.
That's right.
Joint affidavit. If, my lord, if there would have been a gunshot injury, man, then a matter difference. No injury, nobody man sustained injury. That is the affair, my lord.
The God save the other side. God save the other side.
I'm both.
You are so aggressive. You have gone with a.
They are not now keeping good relationship between them, my lord.
After killing also, they.
No killing, no.
So let us understand what kind of.
That is true, my lord. In fact, your ship can dispose of, my lord.
I will issue notice.
All of them come, my lord.
I'll put it. I'll give a date, particular date. Let them come.
If my lord, all of them come, my lord. Roja chalchi बहुत लोग कहते हैं रोजा वाला आसन.
After Roja, give me the date after Roja.
यदि सेटा
After Roja.
Identify कर देते तो affidavit दे दीजिए.
When is the date? After Roja.
After
date would
31st.
be- Let it be on 4th. By the time get the CD. Let us see what are the.
Personal person dispense देना से कही
No.
Better.
Don't be so sympathetic towards these kind of people.
नहीं nothing. खेले मानो I am very fair to जो किसी था था.
Then
बड़े इंजूर था तो मुझे किसी कहे ना था.
Then shall I dismiss it and after charging to the
So all समझते पहले.
See the attitude of these people. They went inside somebody's house, somebody's office, and vandalized everything, and shown the rifle. You say that nothing, no allegation.
But 294 or 506.
The sections forget.
380.
It may be 307 also. I don't know.
307, my lord.
Why?
380.
Maybe 3 after charge sheet, maybe 307. Who knows?
Even 307 कौन सी injury नहीं?
Injury is necessary.
कहीं कहूँ ना जाऊँगा टॉस किसी मैंने present
Rifle is used.
All of them present, my lord.
But and after investigation, it is found that he has fired also. We never know.
No, my lord.
We never know.
My lord, all of them present for it. I include not only informal, my lord.
4th, if you want any other date, you tell me. There I can. Which date you want? You tell me. 4th, huh? Okay, 4th. Get the CD. Huh? Let us see what if this much is the allegation, then we can proceed. If it is beyond that, then we'll think of. Yes. CD to call. Issue notice, Mr. Vishwal accept notice.
They have already entered appearance already.
Mr. Ragada,
Mr. Cognizance samala entered appearance and file affidavit.
Yes. On advance notice, Mr. Samal has entered appearance for opposite party number 2 to 5. Mr. Ragada and Mr. Samal conjointly submit that the parties have submitted the right. Investigation in the present case is still going on. Hence, issue notice to the state. Mr. Vishwal accept notice. Call for CD. Release the matter on 4th. Joint affidavit has been filed.
Joint affidavit already filed.
Joint affidavit filed by the parties is taken on.
They do it.
Copy of the same.
Copy sir, already sir. दे दीजिए.
I have to verify the aspect of settlement and submit a report. Yes. Yes. Any very urgent matters? Very urgent matters.
That's 77.
One after another. 70?
76.
If it's only I will not hear.
I am praying for interim bail Miller since the petitioners were Miller custody more than 4 years. And
77.
77 modification order dated, my lord, 4/3/2025, my lord. My lord, in this issue notice the opposite party opposition of the order dated 11/2/2025 passed by Lawrence authorized officer special court of Bhubaneswar confiscation in the state, my lord. And the condition, my lord, furnishing the bank guarantee of the fee course, my lord. And my lord, the problem, my lord, the property seized by the vigilance, my lord. ତେଣୁ ବ୍ୟାଙ୍କ କୌଣସି ରାଜି ହଉନି ମୋର ମର୍ଗେଜ ରଖିବା ପାଇଁ ଗ୍ୟାରେଣ୍ଟି ଦେବା ପାଇଁ ତେଣୁ ଏଇଟାକୁ ଖାଲି ୱେବ୍ କରିବା ଆଉ ଏକ୍ସଟେନସନ ଟାଇମଟା
That is not possible, my lord.
Extension, then
that is the mandate of the act, and your lordship may my lords may kindly appreciate, my lords. Lordship, the DA was more than 3 crores some odd. Your lordship were generous enough to reduce it to 3 crores and have given an ultimatum of 1 month.
Then it needs complete hearing of the main matter.
Yes.
I can't review like this. Installmentally, you can't take a release. You give concession, okay, 50% I gave, then you move an application for modification. This installment business will not.
As per law, अनुसार चार 2000 the extension time टेकन ना चेष्टा करी मतलब time टेन के
I can extend the time.
The previous time is not yet expired yet. It will be expiring on 4th. Yes.
I can extend only.
It's up to your lordship.
24th April.
Yes, my lords.
মানে মোর চার 2000 কেসল ব্যাংক গ্যারান্টি দেওয়া ପାଇଁ মাইনর ডাইরেকশন করছেন চার
Within a month.
No. Where have we said? 4.
Petition case established a period of 3 months subject to punishing bank guarantee of
Paragraph 4.
within a period of 1 month.
Lordship may kindly have a glance at paragraph 4.
I'll extend that one.
Yes.
The petitioner is seeking modification of the order dated 4/3/2025. 25. He seeks extension of time for filing furnishing bank guarantee for another period of 1 month. For reasons stated in the application, the same is allowed. 1 more month is granted to the petitioner to furnish bank guarantee pursuant to the order dated 4/3.
Lordship may kindly clarify no further extension.
It is made clear that no further extension shall be granted in any circumstances.
Grateful, my lord. So grateful.
We will adjust the next week or day after tomorrow.
Item number 93, my lord, why has stopped, my lord, for the
I am not taking up, so there is interim order will continue.
Yes.
My lord, item number 93 already I have mentioned, my lord, in the first order. Compromise matter, my lord, wife and husband have stopped the court.
91.
93, my lord.
93. Compromise matter means what are the offences?
498 only they have resolved their disputes and
Have they come?
Yes, ma'am.
Then I'll do it. Yes.
Okay.
One minute. Let me finish. Where are they?
My lord, here is, my lord.
Huh?
Present, my lord.
Where is the Simran B. Sahu and Priti Priyadarshini Sahu? Just ask her. You have settled the dispute? Yes, madam. It's very dangerous thing you don't understand. Except FIR, you have not filed anything. File counsel for the petitioner seeks to place on record additional document. Lease the matter on such and such. When can they come? Ask that lady when she can come.
Day after tomorrow, my lord.
You can come.
When can you?
Tomorrow also second.
Tomorrow can you file all this?
My lord.
Bring tomorrow, huh? Tomorrow. Okay.
Item 7.
Item
70.
The only problem is, and there was a stay order till next date 4/12/2018. But that is because of that Asian restructuring case, the trial proceeding, but now that has been buried by the Hon'Ble Office. I am only praying your lordship may take up any day your lordship pleases that the stay is continuing. That much clarification. I am not taking up means stay continue. I said that it goes in bracket. ଆଉ ରିଷ୍ଟୋର ମାନେ ଯୋଉଟା ଭ୍ୟାକେଟ ହେଇନି ସେଟାକୁ କରୁନାହାନ୍ତି ଯୋଉଟା ଭ୍ୟାକେଟ ହେଇଯାଇଛି 70 ଲେଖ ଦିଅ 80 ହଁ 80 4/12/2018 lease the matter for final disposal on such and such day they wrote it and interim order to continue
98 my lord. Item 78.
86 the interim order 86 na
76.
let it come tomorrow day after
Items
98. That
tomorrow day after you'll give
that 98, my lord.
Item 78.
Yesterday it was there. Today your lordship had fixed it because the lower court has fixed it today. That 311 application has been rejected. Other side they said that I am not.
What happened next today?
Today the matter is there. So the court wants to know what happened today. Right now I got in.
Tell the court that it is adjourned. What to do?
Then your lordship may stay. Your lordship may stay there, call it some other day.
I can't stay like this. Stays, you know what is happening in the stay. 92 the stays are pending. Giving a stay order is very easy. Thereafter
your lordship may say
suddenly will not be available. His junior will come. Adjourn.
My lord,
morning also mentioned.
My lords, it's not proper, your lordship. Your lordship may say I will file a petition.
Let it file a petition.
That your lordship may say and copy in course of the case.
But 80.
Item number
98 both the matters.
Your lordship thinks, your lordship thinks a date, your lordship. 98, I am for the opposition party.
Leave the matter for file the hearing. Meantime, petition may move application to the High Court for.
Opposite party is there, your
Your
lordship.
lordship, I am for the opposite party in the 98 case. Your lordship thinks a date for the hearing of this.
Cases I'm fixing. Yes.
88. 88, your lordship, your lordship is supposed to be closed, but that's wrong.
I'll take up tomorrow or day after. There is a reason.
I may be
It
pardoned.
will not be urgent. All the matter tomorrow or day after.
I may be pardoned, my lord.